ಫಸ್ಟ್ ವೀಕ್ಲಿ ಸಫಿಷಿಯನ್ಸ್ ಇಲ್ಲ ಸರ್, ಆಮೇಲೆ ಇಲ್ಲಿ ಮೆಮೋಸ್ ಇಲ್ಲ, ಮೆಮೋಸ್ ನಂತರ
any mentions through video? Any memos?
Suspension of sentence.
Two keys are already been ordered and one is
Is it for orders? Which year's matter? No, 2021 final hearing is not being taken. Yes.
50%
Huh. In recovery gain memo. ಅದಕ್ಕೆ ಐಎ ಹಾಕಿ ಐಎ ಬಂದ್ರ ಮೇಲೆ ಅವರು ಪೋಸ್ಟ್ ಮಾಡ್ತಾರೆ, ಮೆಮೊ ತಗೊಳ್ಳಲ್ಲ. ನಿಮ್ಮ ಐಎ ಆರ್ಡರ್ ಇದೆ ಅಂದ್ರೆ ಸೆಕೆಂಡ್ ಡೇಗೆ ಲಿಸ್ಟ್ ಆಗುತ್ತೆ ಇದ್ಮೇಲೆ. Next week. Any mentionings?
My lord, serial number 90, my lord.
All the cases.
After this, petition first time, serial number 1, Syed Khalil Pasha. Serial number 1, Syed Khalil Pasha.
None appeared. 1 minute time is good.
Serial number 2, Raj Prabhu.
2 to 7 1.
Serial number 8, second time.
8 to 11 finally 1 week. Finally 1 week.
Third time, serial number 12, Anil Ghosh, TR.
for the petitioner, my lord. I pray for a week time, my lord. I pray for a week's time, my lord.
Finally 4 days, if not, the court will proceed to order. After dismiss 8-11. Yes.
Serial number 13, Santosh G. Gogi.
None of your same.
14,
Appear for petitioner, my lord. Kindly 1 week time may get granted, my lord.
Order serial 12 4 days. Yes.
serial number 15, fourth time, Mane Shivaji Hanmantappa.
The registry says office objection not complied with. ವಕೀಲರೇ ಇಲ್ಲ ಅವರು ಬರೋದು ಸೈನ್ ಹಾಕಿದ್ದಾರೆ ರಿಜಿಸ್ಟ್ರಾರು ನಾಟ್ ಕಂಪ್ಲೈಡ್ ಅಂತ ಒಂದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ. ದಿವಸಕ್ಕೆ 200 ರೂಪಾಯಿ ಕಾಸ್ಟ್. At the request of the learned counsel for the petitioner as a final of chance 2 days time as period is granted to comply office objection. However, on a cost of ₹400 payable by the petitioner to the legal services committee of this court during the course of the day and filing a complaints memo along with receipt to that effect in the registry. In case the office objections are not completed within time, this matter on 7/11.
Serial number 16, Melin Sebastian.
appear in this matter either physically or through video conference. Non-conflict. On 21/10/2022, this with the following observation. Effect of the above, even after granting opportunities of not less than 4 times, including final after opportunity, the appellant has not shown any reason for non-compliance. Is the matter stands. Petition stands dismissed for non-prosecution and for of office subject. Yes.
Seal number orders, seal number 17, P.N. Hegde, Kalimullah Sharif for deceased respondent.
Lords, I have already filed this amended petition in the registry on 31st of last month, and I have served the copy on Mr. Kalimullah Sharif also. Probably it has not been placed along with the main file, my lords.
Probably you might have noticed the difference between 2 months as a period of 30 days. Our registry has considered it as less than few hours, less than 24 hours, since yesterday was a holiday.
Yes, my lords. Yesterday was holiday. Carried out the amendment also, and amended petition also has been filed in both the cases.
The counsel for the petitioner appearing through video conference submits the amended memorandum of appeal along with the memo has been filed in the registry. It has put up the same this morning. The counsel for the respondent is present, copy bandide, and acknowledges the receipt of the copy of amended memorandum of petition. The next stage of the matter is this matter on 3/11/2022. Tomorrow. Yes.
Seal number 18, V.R. Balraj, K. Chandrasekhar Achar for respondent. Respondent served Srimati Lata Bai, Lilavati Bai.
For the petitioner is physically present and GP files a report. Notice upon the the respondent is shown to have been served. The respondent is physically present and identifies person as a respondent. In case ನಡೆಸಬೇಕಲ್ರಮ್ಮ identifying herself as Srimati Lilavati Bai, submits that she is in great financial difficulty. I said she cannot endure great financial difficulty and that she has to take care of her actually able son also. I said, not engage the advocate on her own and prays for the assistance by the court. Of the above, the counsel Srimati Archana is appointed as amicus curiae for the respondent. Its notice of the respondent copy LED. Respondent to the counsel for the petitioner is directed to furnish the entire set of criminal revision petition along with annexures to it. The learned amicus curiae Srimati K. Archana during the course of the day. In addition to the above, the said learned counsel, the learned amicus curiae is also entitled for the copies of exhibits, depositions, and other necessary and relevant documents. The records including PCR and ACR free of cost from the registry. If any such request is made, the registry to furnish the same to her within a week from today. It's a matter on 9/11. ಅವರಿಗೆ ಅವ್ರಿಗೆ ಫೋನ್ ನಂಬರ್ ಕೊಡಿ, ಫೋನ್ ಮಾಡಿ ಮಾತಾಡ್ಲಿ. ನಿಮ್ಗೆ ಹೈಕೋರ್ಟ್ ಲೆಕ್ಕದಿಂದ ಒಬ್ರು ವಕೀಲರನ್ನು ಕೊಟ್ಟಿದೀವಮ್ಮ. ನಿಮ್ಗೆ ಹೈಕೋರ್ಟ್ ಇಂದ ಒಬ್ರು ವಕೀಲರನ್ನು ಕೊಟ್ಟಿದ್ದೇವೆ. ಹೆಂಗಸರು ವಕೀಲರೇ ಅವರು. ಅವ್ರು ಏನ್ ಮಾಹಿತಿ ಕೇಳ್ತಾರೆ ಆ ಮಾಹಿತಿನೆಲ್ಲ ಅವ್ರಿಗೆ ಕೊಡಿ, ಏನೇನಾಗಿದೆ ಏನು ಅಂತ. ಅವ್ರು ಫ್ರೀ ಆಗಿ ಕೇಸ್ ನಡೆಸ್ತಾರೆ. ಅವ್ರ ಫೋನ್ ನಂಬರ್ ಇವ್ರು ಕೊಡ್ತಾರೆ. ಆಮೇಲೆ ಇವ್ರ ಫೋನ್ ನಂಬರ್ ತಗೊಳ್ಳಿ, ಅವ್ರ ಹತ್ರ ಮಾತಾಡಿ ನಿಮ್ ಹೆಸರು ಹೇಳಿ. ಹೈಕೋರ್ಟ್ ನಿಮ್ಮ ಹೆಸರು ಹೇಳಿದೆ, ನಮ್ ಕೇಸಲ್ಲಿ ನೀವಿದ್ದೀರಂತೆ ಅಂತ ಹೇಳಿ. ಈ ನಾಡ್ದು 9ನೇ ತಾರೀಕು ಇದೆ ಕೇಸು. 9ನೇ ತಾರೀಕು ಅವ್ರನ್ನ ಕರ್ಕೊಂಡ್ಬಂದು. ಎಸ್.
Serial number 19, Danappa, Pradhanappa Padipate.
We are the petitioner, my lord. We are the petitioner. We already complained the file and also we have paid for 1,000 rupees cost, my lord. Serve for notice, my lord.
Counsel for the petitioner is appearing through video conference. The alleged delayed payment of the cost is accepted. The registry to proceed further in the matter. Yes.
Serial number 20, Mahesh PJ.
The order before your lordship is the order of the Honorable Sessions Court under section 28 of Domestic Violence Act.
Only thing you are required to do is seeking a conversion of this matter into criminal petition. Several other matters are routinely, regularly being converted into petition. You need not have to go anywhere else. Allahabad full court is that is Supreme Court. What? Which court that has said not maintainable is the Supreme Court. Which court that is said is maintainable is a High Court, not to our High Court. It is some other High Court. ಆಗ್ತದೆ ಎಲ್ಲದನ್ನು ಮಾಡಿ ನಿಮ್ಮನ್ನೆಲ್ಲ ಕೇಳಿ ಮಾಡಿ ಎಲ್ಲ ಮಾಡ್ಬೇಕಂದ್ರೆ ಇಲ್ಲಿ ಮತ್ತೆ ಲಾರ್ಜರ್ ಬೆಂಚ್ ರೆಫರ್ ಮಾಡ್ಬೇಕು. ಅದು 2 ವರ್ಷ ತಗೊಳ್ತದೆ. ಅತಿ ಬುದ್ಧಿವಂತಿಕೆ ಅಂತ ಹೇಳಿದ್ರೆ ಬರೀ 2 ಸೆಂಟೆನ್ಸ್ ಒಂದು ಹಾಳೆಯಲ್ಲಿ ಬರೆದು ಕೊಟ್ರೆ ಮುಗಿದು ಹೋಗ್ತದೆ. ನೋಡಿ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ಇದೆ, ಪ್ಯಾರಾ 19 ನಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. ಅದನ್ನ ಸ್ಕ್ರೂಟಿನಿಯವರು ಹಿಡ್ಕೊಂಡು ಕೂತಿದ್ದಾರೆ. ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೇನೆ, ನನ್ನ ಮೆಮೊ ಹಾಕಿ ಕನ್ವರ್ಷನ್. Request of the learned counsel for the petition and magistrate passed over. Yes.
Hearing of internet application. Serial number 21. Consider
Your IA deserves to be dismissed in limine. You cannot say seek multiple prayers of different, including on the merit in the IA. If at all you want to deposit the amount, say for that a specific prayer has to be made seeking extension of time. Not with this kind of IA, including the prayer for the fixing the fresh dates of conducting cross-examination of witness and to lead defense evidence, etc., etc. No, you have to file a fresh IA. Yes.
Mandate back to the election was 50% and date was fixed for cross-examination and also 30%. See, order runs have sought for this. Section is not deposit 50%. Right, what was used to close the case. Unless the date is fixed, I cannot go in cross-examination.
Exactly, you cannot go for that. This is not the IA you are supposed to fight. Yeah, there is another IA, another prayer, another provision of law. You should pursue that. Yes, these three matters were listed at the memo moved by the learned counsel for the respondent. However, the learned counsel for the respondent, even after getting these matters listed, by moving specific memos, has neither present physically nor through video conference. Reasons are for his non-appearance. Thus, the respondent has not properly used, not properly used the precious time of this court and wasted the time of this court by moving a memo and getting this matter listed, but having remained absent when the matter is taken up. As such, a cost of rupees 500 into 3, but as such a cost of rupees 1,500 is imposed upon the respondent payable Legal Services Committee of this court in 2 days from today, within a day from today, and filing the complaints memo along with the receipt to that effect in the registry. Next line.
Sufficient. I have both.
You have moved the memo. You are for petitioner, right? Did you move the memo through email? This is email. But ಇದನ್ನ ಯಾಕೆ ಕೊಟ್ರಿ? Memo, which instance? You have misled the court. You have misled the court. ಜವಾಬ್ದಾರಿ ಬೇಕು. ಮೇಲಿದಷ್ಟು ಕೊಡಬೇಕು. Learned counsel for the petitioner alone physically present. Learned counsel for the respondent not present. For submission of the learned counsel for the petitioner on IA 1/22, peruse the said IA filed under so and so. Since the intention of the petitioner is to seek the extension of time to deposit the portion of the fine amount, which is said to have been ordered by this court. 8/10/2021, but prayer made in the IA is a complex prayer where extension of time is not sought for, but various other reliefs are sought for. Hence, reserving liberty to the petitioner to file appropriate IA in accordance with law, provided if he is advised to do so. IA 1/22 filed in all these 3 connected matters stands dismissed. Yes.
Number 22, Prabhakara M. A. Vijay Kumar Bhatt, correspondent. Copy, total copy. Give it copy.
Yes, please.
Per order.
There are concerns from both sides. For submission from both sides on IA 1/22 filed in the petition and the 397 read with section 482 of CRPC, seeking permission to deposit the amount of 3.5 lakh, which was ordered on 22/8/2016. It was ordered on 29/8/2017. The affidavit accompanying the application, the petitioner has stated that he could not mobilize the fund in time. As such, since he is no mobilized the fund, he is seeking permission to deposit the same. The respondent, who was the complainant in the trial court, has opposed the said application by filing his detailed statement of objection, wherein he has stated that even after the order dated 29/8/2017, once again, an extension by 2 weeks was granted to the petitioner on 22/9/2017. In spite of the same, the petitioner did not apply the interim order. The respondent further says the matter is very old matter, as such the main matter itself can be heard and disposed of. Next line, I find more force in the statement of objection. I find more force in the contention taken up by the respondent in the statement of objection. It is appeal where the present petitioner has challenged the confirmation of his conviction for the offence punishable under section 138 of Negotiable Instrument Act, has not made use of the interim order of suspension of sentence granted in his favor more than 5 years back. Even after securing an extension also, he did not comply the direction. Furthermore, he has not filed any application seeking extension of time. By application of time, the order dated 9/8/2017 has ceased to be in existence. As such, also the question of permitting him to deposit an amount beyond 5 years won't arise. Furthermore, the criminal case from which the present revision petition has arisen is of the year of 2014. Such it is 8 years old criminal matter. Hence, the main revision petition itself can be heard and disposed of. Hence, IA. Or IA disposed of. A perusal of the art sheet would also go to show that after obtaining the interim order, the learned counsel for the petitioner had remained absent in this matter. As such, on one occasion, that is on 28/9/2021, this court had even warned the petitioner of appointing an amicus curiae in case if his counsel failed to appear on the next date of hearing. Thereafter, another counsel entered appearance for the petitioner. Thus, the petitioner's crowd has not been diligent in prosecuting the matter. For these reasons, I do not find any reason to allow IA 1/22. Accordingly, IA 1/22 stands dismissed.
Number
You can
23,
execute the warrant. Yes.
serial number 23, Raghavendra SH, MP Chandrachud for respondent.
What? File it now. Give it right now. Is anything more to say than what is stated in your statement of objection? That counsel from both sides. That counsel for the petitioner has filed his statement of objection to you. About 21. 1/21 filed by the respondent hearing and the second is seeking the release of an amount of rupees 1,26,000 said to have been deposited by the petitioner on 13/2/2020. And petition is the petition filed by the petitioner challenging the confirmation of his conviction by the session judge's court for the offense punishable under section 138 of the Proceedings. Please go. By virtue of the suspension of sentence passed by this court, the petitioner is said to have deposited a sum of rupees 1,26,000 on 13/2/2020. It is the said amount the respondent, the complainant, has sought for releasing in his favor. To the petitioner, subpara, in his statement of objection, stating that the applicant has not shown the reason as to why the said amount is to be released in his favor, but the fact remains undenied that the present respondent of the applicant herein was the complainant in the trial court, who times himself to be the payee under the check in question. Thus, he has made the present application seeking release of the amount in his favor. The other contention taken up by the petitioner opposing the application or consideration being purely on the merits of the case Those contentions need not be looked into at this stage for disposal of the present idea. As such, the under consideration be allowed on conditions. Accordingly, a 1/21 is allowed and the amount of rupees 1,26,000 said to have been deposited by the petitioner on 13/2/2020 in this court be released in favor of the respondent herein on his due identification and in accordance with law, however, subject to the petitioner executing an indemnity bond to the said amount. Satisfaction of the releasing authority. The satisfaction of the registrar judiciary and also furnishing a surety for the like sum to the satisfaction of the very same learned registrar judiciary. Release of amount is also subject to further condition of the respondent herein bracket complainant reimbursing the said amount provided it is ordered to do so by this court together with the interest which may be ordered by this court on the amount released. Are you allowed ಅಂತ ಬಂತಲ್ಲ? Yes. ನೀವು ಇದರಲ್ಲಿ ದಿಸ್ ಕೋರ್ಟ್ ಅಂತ ಬರ್ದಿದ್ದೀರಿ, ನಾನು ದಿಸ್ ಕೋರ್ಟ್ ಅಂತ ಬರ್ಸಿದ್ದೇನೆ.
As ordered by this court. But made by
ನೀವು ಡೆಪಾಸಿಟ್ ಎಲ್ಲಿ ಅಂತ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಬರೀಲಿಲ್ಲ. ನೀವು ಒಂದು ಕಡೆ ನಾನು ಅದನ್ನ ಇಷ್ಟೊತ್ತು ಹುಡುಕಿದೆ. ನೀವು ದಿಸ್ ಕೋರ್ಟ್ ಅಂತ ಬರ್ದಿದ್ದೀರಿ, ನಾನು ದಿಸ್ ಕೋರ್ಟ್ ಅಂತ ಬರ್ದಿದ್ದೇನೆ. Directing the petitioner to deposit 30% of the check amount of so and so before this honorable court. ನೀವು ಏನ್ ಬರ್ದಿದ್ದೀರಿ ಅಷ್ಟನ್ನೇ ನಾನು ಅದ್ರಲ್ಲಿ ಬರ್ಸಿದ್ದೆ. Yes, next.
Seal number 24, Nagendra Shetty, Shivashankara A for respondent.
Which is document number 1 you have filed, you have mentioned in your application. Then why you have shown that you have produced that as an annexure to this application? Once for the applicant is present. But on IA 1/22, perused IA 1/22, which is filed under section 148(3) of CRPC, seeking release of the amount said to have been deposited in CC number 9151/2003. The application is bereft of the details as to the quantum of the deposit, dates of the deposit, and its due receipt number. Further, though it is shown in the application that the copy of the judgment of the Honorable Magistrate is produced with the application as document number 1, but permittedly, no such copy is produced with the application. In view of the same, the application stands rejected as bereft of necessary details. However, reserve liberty to the applicant to file a fresh application in accordance with law, provided if she is advised to do so.
Seal number 25, Mohan Chandra P. Nagaratnama, respondent, sir.
For the submission of the counsel for the petitioner on IA 1/22, filed by the petitioner under section extension of and by a month. The order is issued 11/3/2022. The applicant, though, has stated that she was suffering with spondylitis, was under bed rest, but the same can't be a reason for non-compliance of the order. It could have been applied through her agent, including the learned counsel, for which her physical presence was not necessary. However, considering the nature of the petition, I'm of the imposing cost. They can be allowed. Currently, A1 was allowed a cost of rupees 5,000 payable with the petition to the legal services committee of this court within 2 days from today and filing a complaints memo along with. To that effect in the registry. Of this court. The registry agrees subject filing of complaints form along with receipt to that effect. The time period granted on 11/3/2022 is extended for a period of 1 week from today. Is it clear that no further extension of time will be granted in this? In case the extension granted today is not utilized by complying the
Sir,
terms imposed today, including deposit of the cost amount. Today's order,
to live telecast ಆಗ್ತಿದೆ ಇವತ್ತು.
the petitioner. Yes.
Serial number 26, Rajesh A. Shivshankar, for respondent. Serial number 26, Rajesh A.
Yes, yes. And respondent by in this case, my lordship. The respondent had filed a serious case in 6/2019 before the trial court, my lordship, seeking it for maintenance. And trial court has passed an order on 17/1/2019, my lordship, export a order interim order for pay 10,000 plus 5,000 rupees for the dead sons, my lordship, son, to 15,000 rupees, my lordship. After that, my lordship, the urgent petitioner has challenged in that order, said order before the session court in criminal appeal number 675/2020, my lordship. And in meantime, my lordship, respondent wife also challenging this announcement of the criminal appeal 470 of 2020 before the, and both order has been clubbed, my lordship, 675, 470, my lordship. And 470, wife petition has been allowed and husband petition has been dismissed, my lordship. And same order has challenged before this honorable court by way of the criminal RP, my lordship, 647 of 2022. And this honorable court on 21/2022, my lordship, they have been stayed, my lordship. For the 470 of 2021 has been stayed, and the petitioner shall continue to pay the interim maintenance awarded by the trial court, my lordship, pending disposal of the remedial petition. This honorable court has stayed, my lordship, 21/9/2022, my lordship. After that, my lordship, the urgent trial court, my lordship, trial court order dated 1/10/2022. The trial court has been observed for that. This, however, the Honorable High Court of Karnataka has restored this Honorable High Court of Karnataka restored the order of this. Honorable High Court of Karnataka not restored this order, only appellate court order has been restored, my lordship. Trial court interim order shall continue, my lordship. After that, my lordship, the petitioner, the due amount, arrears of the due amount has been not been compared, my lordship. And in mean, a trial court has issued the FLW. Based on the trial court has recalled the FLW. And the due amount, the respondent husband had to pay the 4,80,000 rupees, my lordship. And memo, the petitioner, respondent wife had filed a memo of calculation on 28/9/2022 from a memo of calculation before the trial court, 4,80,000 due amount, my lordship. And the petitioner stated in the para 6, my lordship, petitioner stated in his petition in page number 6, my lordship, para 13, my lordship. And he has paid 6,20,000 rupees till November 2021, my lordship. In November 2021, my lordship. And he has filed the criminal RP, my lordship, 16/4. Criminal RP, my lordship, 18/4/2022, my lordship. Due amount he has to comply, my lordship, along with the education expenses. And time page number 61, page number 41, my lordship. Page number 41.
1 minute.
The trial court order, my lordship, page number 41, my lordship.
According to you, he has not complied the interim order granted by this court on 21/9/2022. Right?
Yes, my lord, 21/9/22, my lordship.
He has not complied the said order. Yes, what do you see? What you are filing now?
Rate wise, you have paid that amount, 15,000. That rate wise, you have paid since from April 2015 to October 2022. The total amount, the 6,85,000.
Now, have you filed your objection to this IA?
This matter, this application filed by the.
Now, is that statement of objection?
This is the documents to pertain to the main contention. I will file my statement of objection.
Why did you not file hitherto?
Because some documents were misplaced, that amount which was paid to the respondent, the date was misplaced. That's why we have said that based on the statement we have prepared and we will this matter.
There are counsel from both sides present. The petitioner who could have filed his statement of objection if any to IA 2/22 has not filed the same and prays for a short accommodation. Granting of any such time would be, though with cost, but however, considering the submission made by the petitioner, made by the learned counsel for the petitioner that the relevant documents were misplaced at his end, and now he has secured the same comma. The imposing of cost, if any, is a deferral. At final opportunity, a day's accommodation is granted to file objection if any to IA 2/22. List the matter on 4/11. Yes.
Still number 27.
7, my lord.
ನಿಮಗೆ ಅರ್ಜೆಂಟ್ ಇದ್ರೆ 4ನೇ ತಾರೀಕು ಬನ್ನಿ.
Still number 27. Shravan Bharadwaj, P. SPP, sir.
At the request of the proxy counsel for the revision petitioner, matter stands passed over.
Still number 28. Chandrasekhara K.
The petitioner,
Notice
please, my lord.
to respondent, sir. Jagdish S. J.
Petitioner, please, my lord. Matter under 138 of any act. Now the respondent is served, please, my lord.
Jagdish S. J. Respondent, sir.
Even
The
check
previous
amount is
occasion, you had made a submission that the parties have settled the matter.
Please, my lord, since the check amount is my lord, small amount of rupees 80,000, my lord, petitioner, my lord, has agreed to settle the dispute. Other side, my lord, those served, my lord, is not appeared before the court today also.
No, before service of notice, you had made a submission that parties have settled the matter. And it
Please.
will be reported to the court in accordance with law.
My lord,
Therefore, had really there been any settlement, the complainant would have definitely
please,
appeared
please.
before the court.
My counterpart informed me that my lord, other side, that is Jagdish, my lord, approached my counterpart at Tiptur. Today morning, my lord, matter may be taken up in the next week, any date may be fixed, my lord. And that I try to keep both the parties, my lord, present before the court and report the settlement. Otherwise, I will go on with the matter, my lord, on merit.
with appearing through the video conference submits the reiterates its submission. That on 11/10/2022 that the parties have settled the matter. Is that to keep present the respondent of the complainant on the next date of hearing and report the settlement. For 7 NIA. Is the matter of 10/11.
Please.
2002 are great. Either to report settlement or to proceed further in
Go ahead.
Serial number 29, Ravi Kumar NR, connected HCGP for respondent.
According to police report, the respondent is served, respondent called out and has remained out.
Serial number 29, Ravi Kumar NR, HCGP for respondent connected.
Yes. Petition for innovation of. Also, he one days. I have given the application, that's why it was not. Yeah, 2 days. Then we post it down.
Counsel from both sides. At the request of the learned counsel, learned HCGP for the respondent. 3 days time is granted to file their objection if any to IA 1 and 2 of 2022. Yes. ಅದಕ್ಕೆ ಬರೀ 2 days ಅಷ್ಟೇ ಕೊಡ್ತಾ ಇತ್ತು. It's the matter wrong. 2 days ಮಾಡಿ. It's the matter wrong. 4/11.
Admission matters, serial number 30, Archana KM, amicus curiae, HCGP for respondent.
Yes. ಕೋರ್ಟನ್ನು ಬಹಳ ಹಗುರವಾಗಿ ತಗೊಳ್ತಾ ಇದ್ದೀರಿ ಕಳೆದ 4 ಹಿಯರಿಂಗ್ ಇಂದ ತುಂಬಾ ಹಗುರವಾಗಿ ತಗೊಳ್ತಾ ಇದ್ದೀರಿ. ಇದು ಸಂಬಂಧವಿಲ್ಲದ ಸಬ್ಮಿಷನ್. ಯಾಕೆಂದ್ರೆ ಅದರ ನಂತರ ಬಹಳಷ್ಟು ಮಚ್ ವಾಟರ್ ಹ್ಯಾಸ್ ಬಿನ್ ಫ್ಲೋನ್ ಇನ್ ದಿ ರಿವರ್ ಆಫ್ ಗಂಗಾ. ನಿಮ್ಮ ಕಕ್ಷಿದಾರ ಒಳಗಡೆ ಹೋಗುವವನಿದ್ದ. ಈಗ ನೀವು ಇದರಲ್ಲಿ ಏನ್ ಮಾಡ್ಬೇಕು, ಏನ್ ಮಾಡ್ತೇನೆ ಅಂತ ನೀವು ಅಂಡರ್ಟೇಕಿಂಗ್ ಹೇಳಿದ್ದೀರಿ. ಓರಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀರಾ, ಸೇಕಿಂಗ್ ಡಿಸ್ಚಾರ್ಜಲ್ ಆಫ್ ದಿ ಅಮಿಕಸ್ ಕ್ಯೂರೆ ಅಂತದೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ವಾಪಸ್ ತಗೊಂಡ್ರಿ. ಅದು ಅಪ್ಲಿಕೇಶನ್ ಅದು ಎಲ್ಲಿ ಹಾಕಿದ್ದೀರಿ ಕೊಡ್ರಿ. ಅದು ಯಾವ್ದು ಹಾಕಿದ್ದಾರೆ, ಯಾವಾಗ ಹಾಕಿದ್ದೀರಿ? 31st May. Learned counsel for the petitioner. Learned amicus curiae for the petitioner. Archana KM and learned previous counsel for the petitioner. Sri Joyce Somashekar are physically present. Learned CGP for the respondent is also present. Learned counsel say J.S. Somashekar submits that he has filed in the registry seeking relieving of the amicus query in the matter and seeking permission for him to proceed further in addressing argument in the matter. Addressing his submissions in the matter appearing for the petition. He submits that the said application was filed in the registry on 31/10/2020. However, the registry has not put up the said application. Call the matter at 2:30 p.m. The registry to put up the application filed in the.
Number 31, Shivashankar SK, Arvind M. Neglur for respondent.
Appear for respondent.
Filed by dismissal state. First appellate court. Appeal against the acquittal.
Reasoning of the learned magistrate are in paragraph number 12 of the judgment.
The counsel from both sides present. This matter in the week after.
Number 32, Siddharth B. Muchandi, HCGP for respondent.
The counsel for the petitioner submits that as per the information received by him this morning, the petitioner is demised and is no more. Place for a short accommodation to do needful in the matter. Each time is granted to do needful in the matter. Just 10, 11.
Number 33, Prasanna VR, Karthik Patil for respondent.
You are for the accused.
I am for the case of the complainant.
We will take up this matter after 2 weeks. This is a recent matter.
Please.
Yes. The counsel for the petitioner is physically present. The matter is of the year 2019. The court is held up in taking the matter of the year 2013. This is the matter after 2 weeks. Yes.
Number 34, Firoz Nizam, Sharat Kumar GM for respondent.
Also for the petitioner, neither present in our video conference. Also for the respondent alone present, hence the matter did not be presented.
35, Venkatesha Mauni, KM, HCG correspondent.
That is passed over next.
Then number 36.
We will hear and dispose of the main petition itself in the next week. That's one thing from both sides present. Since the TCR and SAR have already been received, the main matter itself can be heard and disposed of. It's the matter of 9/11/2020.
37, Raju P.
Proceeding, my lord. As continued. The appeal filed by the session court has challenge here for suspension of
40% to its trial court. 1 lakh to sureties, PCR, ACR, emergent notice.
Serial number 38, Muniappa Chandrasekhara K for respondent.
Respond.
Because the respondent has filed objection to IA.
No, my lord, I have not filed any objection. Good.
I have deposited 40% of the amount. %, I have not deposited. There are counsel for the petitioner. Public applicant in IA 2/22 is physically present. There are counsel for the respondent is appearance through video conference and submits that the petitioner, though was permitted to deposit 40% of the final, inclusive of the amount already deposited, if any, before the trial court has not yet deposited the said amount. The learned counsel for the petitioner considers that the petitioner has not deposited the 40% of the amount, though permitted on 27/9/2022. Further, the learned counsel for the petitioner submits that in similar matters, court had ordered to deposit 35% of the fine amount. Assessed the petitioner has not deposited 40%. The above is the submission made from both sides on IA 2/2020. That is the said IA 2/2020. But with the petitioner in section 397(1) now. Excellent. The petitioner is the accused who has challenged the confirmation of his conviction by the Sessions Judicial Court for the offence punishable. Section 108 of negotiable instrument. The fine imposed upon him was ₹10,05,000 by the trial court, which was further confirmed by the Sessions Judicial Court. Excellent. Though pending IA 2/2022, the petitioner was permitted to deposit 40% of the fine amount as long back as on 27/9/2022. Yet, admittedly, the petitioner has not deposited the said amount. In the above circumstance and also considering the reasons shown in the I-ended consideration, the inference that can be drawn is the opportunity of depositing 40% of the fine amount, though was granted to the petitioner, has not been used by him. That's like in the above circumstance, IA 2/2022 allowed in part, however, subject to the following conditions. %, trial court, 1 lakh, 2 sureties, emergent notice, TCR, SCR, by virtue of the above order passed on IA 2/22. The benefit of permission to deposit 40% of the fine amount granted on 27/9/2022 would not inure to the benefit of the petition. Yes. Emergency notice ಬರಲ್ಲ, respondent ಇದ್ದಾರೆ. Next one.
Argument matter, seal number 39, SM Chubiraya, SP Lakshmi for respondent.
Not responded to the last petition, you last has what was the settlement is going to give. Amount is going to give this.
That was heard at length from the petitioner side. Yes, you have not yet commenced your argument in the matter. After hearing the argument of the learned counsel for the petitioner, you sought for time to address your argument. Since in the meantime, an element of settlement was noticed by the court asked you, permitted both the parties to continue their effort for settlement if any in the meantime. ನಡೀತಾ ಇದೆ ಅಂತ ಕೇಸ್ ಮುಂದೆ ಹಾಕ್ಲಿಕ್ಕಾಗಲ್ವೇ? ಹಳೇದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಅವ್ರದ್ದಾಗಿದೆ, ನೀವು ಮಾಡಿಬಿಡಿ, ಕೇಳಿಬಿಡೋಣ ಅಂತ ಆರ್ಗ್ಯುಮೆಂಟ್. ಎಲ್ಲ ಟೈಮ್ ಕೊಟ್ಟಾಗಿದೆ. ಇಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್ ಅದೆಲ್ಲದನ್ನು ಕೇಳಿಸ್ಕೊಂಡೆ ನಿಮಗೆ ಸಮಯ ಕೊಟ್ಟಿದ್ದೆ. ನೀವು ಕೇಳಿದ ಹಾಗೆ ಸಮಯ ಲಾಸ್ಟ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೇನೆ. ಲಾಸ್ಟ್ ಟೈಮ್ ನೀವು ಹಾಗೆ ಹೇಳಿದ್ವಿ, ಕಾಪೀಸ್ ಇಲ್ಲ ಪೇಪರ್ಸ್ ಇಲ್ಲ ಅಂತ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೇನೆ. Yes.
Then accordingly, we totally again or put to the component side by now.
After our argument, such a submission was made to the effect that a settlement is going on. Yes.
9 lakh offer ಕೊಟ್ಟಿದ್ರು.
Please. ನಾನು ಮಾತಾಡೋದು ಪಾರ್ಟಿ ಮೇಕರ್ಸ್ ಇಲ್ಲಿ 9 ಲಕ್ಷ ಅಂತಾರೆ ಕಾರ್ಯಗಾರ ಮತ್ತು 5 ಲಕ್ಷ ಅಂತಾರೆ.
ಅಂದ್ರೆ ನಮ್ಮ ಪಾರ್ಟಿ 5 ಲಕ್ಷಕ್ಕೆ ಅಪ್ರೂವ್ ಮಾಡ್ತೀವಿ, ಇವರು 9 ಲಕ್ಷ ಹೇಳ್ತಿದ್ದಾರೆ.
ಇಲ್ಲ ನಮ್ಗೆ ಸ್ವಲ್ಪ
Kindly pass on that, take instruction from my.
ಇಷ್ಟೊಳಗೆ ತಗೊಂಡ್ ಬರ್ಬೇಕಿತ್ತು, ಇನ್ನೇನು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತಗೊಳ್ಳೋದು.
He's on the way.
ನಿಮ್ಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತಗೊಳ್ಳಿಕ್ಕೆ ನಾವು ನಿಮ್ಗೆ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದು, ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದು. ಪಾರ್ಟಿ ಪ್ರೆಸೆಂಟ್ ಇಟ್ ನಾನೇನ್ರಿ ಮಾಡ್ಲಿ? ಲಾಸ್ಟ್ ಟೈಮ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೇಳಿದ್ದೇನೆ, ಇಬ್ರು ವಕೀಲರಿಗೂ ಹೇಳಿದ್ದೇನೆ. ಈಗ ಅವರು ರೆಡಿ ಇದ್ದಾರೆ, ಅವ್ರ ಪಾರ್ಟಿ ಇದ್ದಾರೆ. ನೀವ್ ಇಷ್ಟಂತ ಹೇಳಿ ನೀವೊಂದು ಪ್ರಪೋಸಲ್ ಕೊಟ್ಟು ಅವ್ರು ಸ್ಟ್ರೈಟ್ ಅವೇ ಹೇಳಿ ಬಿಡ್ತಾರೆ ಆಗುತ್ತೆ ಇಲ್ಲ ಅಂತ. ಅದನ್ನು ಮುಂಚೆ ಮಾಡ್ಬೇಕಿತ್ತು ಅಂತ ಹೇಳ್ತಿರೋದು ವಕೀಲ್ರೆ, ಅದನ್ನ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ. ಡೇಟ್ ಅಂತ ಕೊಟ್ಟು ಹಿಯರಿಂಗ್ ಡೇಟ್ ಅಂತ ಕೊಟ್ಟಾಗ ಇಬ್ರು ವಕೀಲರು ಅದೇನೇನ್ ಮಾತುಕತೆಯೋ ಹೊಡೆದಾಟವೋ ಪ್ರೀತಿಯೋ ಅವೆಲ್ಲವನ್ನೂ ಹೊರಗಡೆ ಮುಗಿಸ್ಕೊಂಡು ಬರ್ಬೇಕು ಒಳಗೆ. ಇಲ್ಲಿ ಬಂದ್ರ ಮೇಲೆ ನನ್ನ ಪಾರ್ಟಿ ಬರ್ತಾ ಇದ್ದಾರೆ, ದಾರಿಯಲ್ಲಿ ಇದ್ದಾರೆ, ಈ ಒಂದು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಮಾಡಿ ನಾನು ಏನಂತ ಕೇಳ್ತೀನಿ, 5 ಲಕ್ಷ ಅಂತ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ. ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೋರ್ಟಲ್ಲೂ ಹೀಗೆ ಮಾಡಬಾರ್ದು, ಹೈಕೋರ್ಟ್ ನಲ್ಲಿ ಮಾಡ್ತೀರಿ ಹೀಗೆ. ಸ್ಯಾಂಟಿಟಿ ಇಲ್ಲ, ಯು ಹ್ಯಾವ್ ಲಾಸ್ಟ್ ಸ್ಯಾಂಟಿಟಿ ಟುವರ್ಡ್ಸ್ ಜುಡಿಷಿಯರಿ ಅಂಡ್ ದಿ ಕೋರ್ಟ್. You don't have least respect to the court. A panchayat in village side would be in a better manner. They conduct in better manner than the proceeding in the high court. For letharginess on your side, that is your client side. The other party should wait for the whole day. Other party counsel should wait for the whole day. Learned counsel from both sides present. They pray for a pause over to make their submission regarding the settlement, if any, or to proceed further in the matter. The matter stands possible. Also, where is your Google?
Number 21, 55.
Okay.
First file memo for conversion. 35 years. ಇನ್ನೊಂದು
27 ಹೊಂದಿದೆ ಅಲ್ರಿ?
ಕರೀರಿ.
74 ಆಗಿದ್ದು. Number 22.
Statement of the correction.
21 coups.
Yes.
20 coups.
Still number 20, Fasto matter.
Called again, counsel for the petitioner not present. Yes, next. Go to the main matter.
Further arguments? Serial number 40. Archana came amicus curiae. Connected. Ashwin Vaish. For R122. Janet S. amicus curiae for R3.
The third division is the first matter. I am appearing for the respondent accused fellows, and in 6009, 6010, I beg to appear, my lord, for the accused petition. That is, my lord, the same summoning order is a challenge. Members will recall they are agreed by the fact that I have not been summoned for 376. And I am agreed by the fact that I have been summoned for all other sections, including outraging the modesty. So I started my arguments accused in 6009 minutes.
For the previous occasion, we read amicus curiae for the petitioner in revision petition 763 of 2011 has addressed their argument. You had commenced your argument for respondent number 1 and 2. So now you have to address your argument for respondent number 1 and 2 in the first matter and for the petitioners in the connected matters. Your argument would be followed by the another amicus curiae for respondent number 3 and the counsel or the amicus curiae for the respondent in the connected.
For the convenience of the court, Manoj may permit me only to hand over a list of dates. I'll give a copy to my friend. Contention is essentially threefold, Manoj. My first contention is that since I'm aggrieved by a summoning order, I have to make an endeavor to convince my lord that no prima facie case is made up. My second endeavor will be, my lords, demonstrate to the court that since admittedly the accused persons were getting beyond the jurisdiction of the trial court, the trial court ought to have exercised its powers under 202 CRPC, conducted a detailed inquiry or investigation before issuing process against the accused persons. Yes. But may kindly have my list of dates. If Malaj will remember, I had started by saying I only take Malaj's attention to 10 dates. And if at all it is convenient, Malaj may consider having 6009 as the file, because Malaj, my pages will match, or I show from this very complaint. Sorry.
Yes.
But we'll see the first date. And Malaj will see the first page of the complaint. But let me get it out of the way that it is their case also that both accused persons were beyond the jurisdiction of Ramanagara district. Kindly see the first paper of the complaint dated 30th 12/2010. What is happening?
Complaint.
As we'll see, the complainant is residing in Chennai and the accused number 1 First, we'll see the array of parties. The complainant is a resident of Chennai, and accused number 1 is a resident of Tamil Nadu, and accused number 2 is a resident of United States of America. I'll come to the legal arguments later, but this point is important because it is their admitted case and my admitted case that we were not present within the jurisdiction.
All these 3 petitions have arisen out of a single complaint. Single complaint. That complaint originally has shown one accused, right? As placed before me at page number 133.
The complaint Manoj will find. Will find the page 14 as per petition number 763, because Manoj, I believe, are seized of 760. That is the first petition where they are the petitions. Unless Manoj is seized of 6009.
Complaint would be same for all the three, right?
Manoj's complaint, same pages would differ. Pages would differ, Manoj, because my petition paging would be different from theirs. Is Manoj seized of the first petition 760?
No, base petition is 763.
Yes.
I go by 763.
So there the complaint will find at page 14. The paperwork which has been 14. Sorry, petition copy. 14.
763, 763 inventory. Statement of objections.
Page 14.
Yes.
Manoj will kindly have in the array of parties. Accused number 1 is a resident of Tamil Nadu.
Yes.
And accused number 2 is a resident of United States of America.
Yes.
That is also my case.
Yes.
Now, Manoj will kindly take my list of dates,
List of dates.
which I just handed over to Manoj and give a copy to the list. We have the second date, 30,010, in my list of dates.
The both of you have gone through the list of dates. They are correct and can be relied upon.
Sitting to copy now. Can I say, as an officer of the court, if Manoj finds a single fact wrong, at that stage, please throw my petition. As an officer of the court, I will be coming before Manoj again and again. That's what I learned from my senior. Clients will come and go. So I have meticulously prepared it. Only difference is my preparation is based on 6009, which is my petition, but I will be able to draw Manoj's attention to the relevant paras from the petition before Manoj's. That is why I'm drawing Manoj's attention to the second date, 30,010.
Yes.
And paragraph 11 of this summary. And Manoj will find at page 19, provided Manoj's and my pages match. Page 19, paragraph 11. What is that? Paragraph 11 of the complaint.
Yeah, 1 minute.
If I'm able to convince Manoj that my list of date matches the complaint and all the averments herein are accepted as prima facie truth, the question that will arise is one, should accused number 2, who's a lady, be summoned for an offense of sexual harassment while sitting in America? Or of extortion when admittedly there is no call between the complainant and her? I am taking my best case Manoj for accused number 3, then I come to number 2. Number 2 is the man.
Do you mean to say that there is no section 120B in the matter?
There is Manoj. I will even satisfy Manoj or make an endeavor that 120B will not be attracted because there is no suggestion of meeting of minds even in the averments of the complaint. There has to be some averment. One simply cannot say that because the complainant thinks that two people know each other, therefore there is a conspiracy. And whether this lady, the complainant, on an allegation of a rape on 13 February 10, waits for 8 to 9 months, appears before different police stations on different occasions as per her own complaint, and then does not go to the police.
Now, at what stage all these aspects has to be analyzed or assessed?
Well, at the
Is it at the stage of the taking cognizance, or are there not any several other, not one, several other appropriate stages where you can keep on placing your defense or your contention?
Well, with greatest respect, my lord, as student of law, can I say one? FC food has been followed till today. And the Honorable Supreme Court and Mallots have time and again held something is such a serious business. It should not be done at the whim and fancy of the complainant. If I am able to demonstrate that there is malafide, there is no prima facie case, even if Mallot goes to the entire complaint, if Mallot comes to the conclusion that, okay, accused number 3 has been wrongly summoned because she is actually the victim of a crime committed by the Swami, whose follower is this complainant. Malafide, as per Bhajanlal, is one of the grounds.
But you are not for accused number 3.
I am for both. I am both for 2 and 3. 4 is Sridhar Mallot, who never appeared, and Mallot had to appoint the reminders. Accused number, I am for accused number.
We have only 3 accused, right? Yes,
Sorry,
you are for 1 and 2.
I am for 1 and 2. Number 2 is a lady.
Yes.
If I am able to demonstrate that the lady, even as per the elements, should not be summoned for sexual harassment and extortion, it is my endeavor to satisfy this. And in that endeavor, this list of dates is there, which is there, it's not mine. That's my endeavor, Malad. Allow me to place my case. Yes, I leave.
Yes.
So, Malad will kindly have paragraph 11 of the complaint.
Yes.
About 8 lines in the middle
Yes.
is an amendment.
Yes.
On the following day, that is 13,010, while the complainant was passing by the restaurant area, ignoring the presence of first accused. Malad will note there is no number 2 here. There is no RP here. He screamed out and called the complainant in a harsh voice, stating that he wanted to see her something on his laptop. The manner and tone in which the first accused speak puzzled the complainant. She gathered courage to walk up to him and inquired what it was. To the shock and disbelief of the complainant, the first accused displayed few poorly shot videos of his molestation of 2 brahmacharinis on his laptop. Not seized, not part of the trial court record. But here, the best evidence rule would apply even at a prima facie stage, that if this material was not before the trial court, would this be accepted as the gospel truth even at this stage? There's nothing. Normally, a rape victim, what does the victim do? Runs to the police, goes in a 156. No, this was a ploy. They go for pre-summoning and get re-summoned. Despite, as per my list of dates and as per their own elements, having appeared before the police earlier in June. I'll come to it. So, one date gets identified here as the date of alleged rape, that is 13,008. Now, kindly have the next para, that is paragraph 12 in this very complaint.
Yes.
Somewhere in the middle, after 3 lines in para 12, still photographs depicting a woman with the face of the complainant and standing with a curtain as a backdrop, and that woman involving in intimate position with the individual who seems to look like Sri Nityanand Swami, which incidentally are the still photographs from the obscene video that the first accused later released to the media in March 2010. So we come to the second date in my list of dates, that a telecast video was released.
One moment.
And again, my lord, for the sake of repetition,
Whether para number 11 speaks that say on 13/2/2010, an incident of rape took place.
no, that is my lord at para 11. That is para 11. Kindly have that. I read it completely. My lord,
Please.
once. Because that is the entire case. If my lord accepts, there is no
Please
need.
read it.
Yes. Because I'm on para 11. I'm on the last 4 lines.
Yes.
The complainant turned into extreme anger and yelled at the first accused to abandon such dirty acts and that she would report the same to Swamiji immediately. The first accused, who was undaunted, warned the complainant to see her own photos before she could complain to anyone. The complainant was shocked and shaken and lost her speech and wondered if the first accused had created anything about her as well. The first accused then informed the complainant that he would show the same to her at a particular room adjacent to the VIP room and asked her to accompany him. All the prior memories of the lunatic gaze and attention that the first accused gave her wreaked havoc and then mentally disturbed complainant accompanied the first accused. Now we are still on 32. I'll read further. After taking the complainant into the particular room, the first accused opened his laptop and showed certain photographs of the complainant on his laptop, which were run as a slideshow. Still photographs depicting a woman with the face of the complainant and standing with the curtain as a backdrop, and that woman involving an intimate position with the individual who seemed to look like Nityanand Swami, which incidentally are the still photographs from the obscene video that the first accused later released to the media in March 2010. The complainant stood in utter shock, grief, and disbelief, not knowing what to do next. At the same time, this is important, my lord, the first accused came down to the floor and sat next to the complainant, who then noticed that the door was locked from inside. The first accused held the complainant by her hands and hugged her instantly. And even before she could react, she was forcefully put down on the floor and the first accused. The complainant began to push the first accused with all her might, but the first accused, being strong and mighty, could not budge. He started laughing in a strange and sadistic manner while lying upon the complainant, attempting to overcome her resistance. The complainant who was scared for her life and honor, screamed, yelled, and begged the first accused. He told her to shut up and told her that his brother, who was in Chennai, has another copy of the photographs that he had displayed to her, and that if she continued to resist him further, he would call his brother and instruct him to Naked magazine and Sunday, and that in no time the photographs would come public domain, and that any complaint that would be lodged by the complainant would not have the desired effect, and instead back on her. The complainant was helplessly lying on the floor, being overpowered by the first accused. He then questioned the complainant if she had ever wondered what all other things he could do to see her suffer more. The complainant was reactionless, and the first accused then boasted that he may appear to look ordinary, but is very well connected politically, to do many more things, and that he and the second RP had planned all this together. Malad was asking me 120B if Malad's judicial conscience is satisfied that a so-called claim by another accused is sufficient for 120B, then yes, I will 120B. If Malad finds that this is a grossly delayed and exaggerated complaint, such a claim by a fellow accused in absence of any obscene video or laptop at the pre-summoning stage, in my humble submission, deserves that the case ought to have been thrown out. It is a strange case, my lord. No CD, no laptop, no photographs before the trial court, mere oral testimony offending 91 of the evidence at the best evidence. Something had to be there. That is the reason police mechanism is there to investigate and recover, and that is why under 202 the police can be directed by the learned magistrate to collect evidence without arresting. That is the sole difference between 156. That I cannot be harassed in that investigation, but the police can verify whether such a thing happened. Why they did not want this investigation done? Because this lady had already appeared in June 10, 4 months before this complaint, before the CID, and given her statement, which is also irrelevant here, where there was no mention of rape or febrile. That is my humble submission. This, what I'm reading before my lord, is the extent from which my friend wants to draw an inference that an attempt to rape. I read further, my lord. Had planned all this together, he then warned the complainant not to reveal the name of the second accused RP and his acts to anyone in the ashram or the police, failing which he would kill her. He then proceeded to force himself upon her and was attempting to disrobe her, stating that he would at any cost have sexual intercourse with her. At that time, the complainant heard some person moving near the room and screamed once again loudly, and someone from outside knocked the door and wanted to go inside. The first accused panicked and then used his finger. Well, this is the extent. Again, the laptop gets closed. There is no laptop. But my submission is this. My list of dates says that her alleged incident of rape is 30.
No. My question is specific. For my one sentence question, your answer would have been in one sentence. You read 3 paragraphs, but did not answer my question.
I'm sorry, friends.
You have mentioned in list of dates 13/2/2010 as alleged offense of rape on complainant. I only asked you to show me that on 13/2/2010 there is a specific allegation that rape was committed.
Attempt. Her highest
Now,
case.
don't you think that rape and attempt to rape are two different? You are opening the encyclopedia and criminal law before me.
I bow down. I bow down. Let us, my lord, accept her case of attempt. Her case is 32 an attempt case because I attempted to discourse.
No, that's what I'm telling you. You could have simply stated, instead of taking 10 minutes and giving a long discourse about what is 156.3 and what is 91, etc., etc. You could have simply stated, you have mentioned it rape, but it's an attempt to rape. I wouldn't have asked you any further question on that date. That is the reason I asked them to ascertain the correctness of the date. You said that, say, you never give any false date, etc., etc.
I would have obviously taken. I understand what is falling from us. It's an attempt according to them. And the attempt according to them is on 13.
Yes.
Now, Manoj, we kindly have paragraph 20
Yes.
of the complaint. That should be at page 26.
Yes.
Because if I read the last line, the first accused, again we are on first accused, there is no second accused. The first accused appears to have suspected that the complainant had intended to report his acts to the police and fearing serious legal action against him, immediately distributed the fabricated videos to various media houses on 2/3/2010. Most of the television channels did not bother to make any pre-telecast inquiries with the complainant or the person concerned and started beaming the videotapes in which a woman who resembles the complainant was seen in an intimate house.
Yes.
So, Malad, from her complaint, we gather that on 2010, that means 1 month after, less than 1 month, about 20 days after the alleged incident of attempt, the telecast was carried out by the DPs. And I allegedly, I as an accused number 1, not 2, released the intimate videos. Now, Malad, kindly see the next date. Malad will find of 3/3/2010. That Malad will find in para 70. At Malad page 25, Malad will turn the page over. Somewhere in the middle. What is happening?
Yes.
Paragraph 17.
17.
The
Yes.
next page, Malad. Somewhere in the middle.
Paragraph 17.
70, 17 of the
Yes.
complaint.
Yes.
I am referring to page 25, which is on the next page.
Yes.
Malad. Please skip 10 lines, Malad. It's somewhere in the middle. It starts the third accused, that is Sridhar. I'm not representing. The third accused then informed. The third accused then informed that few others are involved in this issue and named them as the first and second accused and a prominent Christian missionary and another person whose identity was kept secret. He then promised to bring all the members of the conspiracy Vidadi in Ramnagara district on 3/3/2010 only as a show of faith and demanded the payment of the sum of 25 lakhs. So, Malad, my next date, which I was referring to, Malad, is as per her case on 3/3/2010, there was a demand. Now, Malad will kindly have when she decides to.
This demand was made at Bidadi, right?
But if I read the earlier lines, my lord, it is not clear. Accordingly, they met the third accused, and during negotiations with him, the friends of the complainant expressed concern. But he says, I'll bring them to Bidadi, but I cannot gather whether they are at Bidadi at that point or not. Even if you presume they are at Bidadi, accused number 2 is not there. They claim that the lawyer met them, accused number 3 met them, and made a claim and said, give me 25 lakhs or give us 25 lakhs. Now, the next date is again 3/3/10. But I'm referring now to the complainant's pre-summoning evidence. The pre-summoning evidence followed would be after the complaint. Let's find it at page 30. Let us have the pre-summoning of Ranjita. Let us will have internal page 7 and the running page 36. I'm referring to the pre-summoning evidence of the complaint.
Page 32.
Yes, the relevant portion is at 36.
36. Yes.
But at the top, it should start by towards the other side of
Yes.
the room.
Yes.
Page 30. It's page 38. There is some
30.
discrepancy. Yes, 38. There's discrepancy between my pages and
38.
38.
Yes.
So, Malad, the attempt has happened on 32, allegedly. Telecast has happened on 2nd of March. Demand has happened on 3rd of March, as per her complaint. And in a pre-summoning at page 38, we see the second para. When I was in Kerala, Malad has.
Yes.
I was planning to come to Bidadi on 3/3/10 for final settlement and also planning to take penal action against the all accused for equal cases. So, as an educated lady, as an actress, as not a person who has no means at her disposal, she said, I was planning on 3/3/10 of taking action, but she doesn't. Kindly have the next date, my lord. 4/3/10.
Yes.
4/3/10, my lord. is the date when my lord accused number 1, that is Lenin, makes his complaint. It is not a disputed fact that accused number 1 made a complaint to the police. That FIR came to be registered on 18th March 10. I'm only trying to show, and again, then my lord will put the question to me at this stage, whether it is my defense or whether there is still a prima facie case. Even if I'm able to succeed in showing that the entire gamut of allegation is against accused number 1, then my lord will show indulgence towards for accused number 2. So, my lord, the next date as per my list of dates is 4/3/10. Kindly have page 174. Paragraph 23 of the paragraph 23 of the that should be at
Yes.
page 28.
Yes.
Malaj, before I request Malaj to look at paragraph 24, kindly see my list of dates for a second.
Yes.
There is another date, 18/3 March, which is an FIR lodged by accused number 1. And then there is a date, June 10, where this very complainant appears before the CID. So kindly see paragraph 24 in that date. The complainant immediately after viewing of the said mock video and publication of the photographs and articles connected with the same in print media was completely shattered and destroyed. She went into deep depression and went abroad immediately. Doesn't go to the police. To avoid all further unpleasant situations for herself and her family, she stayed abroad from the beginning of March 2010 and made a brief visit to India in the middle of June 2010, only to cooperate with the CID police in their investigation into the complaint said to have been filed by the first accused, presumably, that is what I'm saying, the malafide, presumably to blackmail Nityanand Swami or the complainant, if possible, and went abroad. My humble submission before my lords is, as per her own showing, after suffering an attempt on her modesty in February 10, the lady appears before the CID on my complaint, that is number 2, not number 3. Again, I'm stressing a lot. The number 3 has been added because she's the victim in the other case, which is prior in point of view. So June 10, she goes before the CID. She's under no threat. She's surrounded by the police. She does not divulge the incident of 13 February 2010. She does not divulge any act of extortion of 3rd March 2010. So there was a demand also of 25 lakhs on 3rd March. It is unnatural conduct. She's not a Pardanashi lady. She's not an uneducated lady living in a small village who is not aware of her. She's a lady who, as per her own claim, has acted in many movies and is a famous personality. To sum up my submission on facts, allow me to say this, my lord. So I do not take my lords again to the complaint. That the only allegation against accused number 2 appears, my lord, in paragraph 3. when she says, first accused told me that he and second accused had planned this together. Whether that beats the test of Pepsi food and the subsequent judgments. And while Malad are examining that, Malad will also see there is a gap of 10 months because Malads have seen the date of the complaint as 30th December 2010, 10 months after the elections. But there are cases and there are cases. These complaints are drafted by lawyers.
Yes.
PS lawyers tend to do a job too well and try and plug in all the holes when making a complaint. It's a fact. Even then, the gap of 10 months, incident of February 10, demand of March 10, not reported for 9 months, even before June 10, before the CID. That's a serious lapse. And a lapse which would at least entitle accused number 2, Aarti Rao, for a relief at Malad's hands. As I pointed out to Malad, the only allegation against Aarti Rao, accused number 2, is para 13. In para 14, very interesting allegation, para 14, Malad, page 23. Malad may see it. Because I know for a fact there are judgments and there are judgments. Unless Malad is morally convinced, I'll get that. So kindly see paragraph 14.
Yes.
Last 5 lines.
Yes.
Too many questions began to surface in the mind of the complainant. She began to wonder why another devotee and who's the organizer of Karnataka activity at Michigan State, United States, has colluded. That's it. Second time my name is. Then Malad will kindly have paragraph 70, page 25. Because they knew I am in America, as per their own showing. Because they knew they could not call me and trap me. Because they knew I will not call them. How could they ever on this? There is no recording. Another point for Malad consideration. Can a learned magistrate, while dealing with a complaint for extortion, where there is a claim that certain mock videos were shown, laptops were shown, can Malad I be summoned? Can I be called in absence of that physical proof, the corpus delicti, the body of the crime? Can I be called and even under 91 called to produce it? No, it offends my constitutional protection right of silence. So can the learned magistrate presume ऐसा हुआ? The learned magistrate had to invoke his powers, which I come to later under 202, and call the police. Please come here. This lady has come after the gap of 10 months. Let us see what is going on. Where is that seat? Where is that laptop? It's there. It is all based in air. It is castles in air because they know once I start facing trial. And Malad sitting as a constitutional court and as a court of record, I will hand over a chart. This is one of the 25 cases filed against me. All over India. When I'm in America, I am supposedly sitting in a cafe in Allahabad. One of the 25 cases. Today, this accused, who she refers as Swami, run away from the country. But I am living here. I continue to do these proceedings. So let kindly see the next allegation at page 70, para 70, page 25, about 10 lines from the top. Because Aarti is not there, because accused number 2 is not there, this is the highest she has to say. The third accused,
Yes.
page 25. The third accused then informed that few others are involved in this issue and named them as the first and second accused and a prominent Christian mission. But there's a very old saying, I don't know whether it's there in our culture. In Christianity, they say even the devil preaches the Bible. So, in this case, the complainant wants to teach that now the Christians are after her It's a conspiracy against her Hindu Guru, and therefore 1, 2, and Christian missionary. Perfect target. So all I'm emphasizing is not. There is again the only reference is that number 3 told me when the demand was made, but I don't tell this to the CID. I didn't feel like it. I can come and tell the court any day. I don't have to tell anyone. Unnatural conduct, my lords. Wide experience. Lawyers rush when they don't tag for a 150/60 because they know in the rape case, in the case of electronic evidence, a private individual cannot collect evidence and the case cannot survive. The CD doesn't do that. That has to be looked into by my lords in terms of Bhajanlal, that my lord, if valid deed is involved, what should my lord do? Should my lord exercise 482 or not? Because my lords are not limited by 3. My lord's powers are not withstanding in the country. Now, my lord, kindly see, does my name, does Aarti's name appear ever again? Yes, it does. Para 30. And in what context? And then I'll come to the sections whether my lord should continue this case against me, even against the existing sections. Para 30, they say, from the course of conduct, the accused 1 to 3 have entered into a criminal process. Para 30, page 3. That's it. That is the beginning and end of allegations against accused number 2, Aarti Rao, a lady. Para 30, my lord, first time.
Yes.
Now, my lord, for what sections has accused number 2 been summoned? 354. Kindly have, my lord, the summoning order dated 4/6/11 and page 12 of my lord's paper. Page 12.
Yes.
Plus, I would like my lord to, I humbly beseech my lord to only consider my arguments right now for accused number 2, Aarti Rao. Because then when ingredients are looked into, my lords will see whether I should be facing this trial or not. I have been summoned under 354. 354 is whoever assaults with intention to outrage modesty. Can I be summoned? Accused number 2. Does he say that Aarti asked me to outrage your modesty? Not even the everment. She says, I'm sure, my lord. I was thinking, why did Aarti do this? It is not even in her mind. Aarti has asked him to do this. So I have been summoned under 354, outraging modesty. I have been summoned under 509, intention to insult modesty. I'm deliberately drawing my lord's attention first to the offences pertaining to sexual assault. Only to try and shock the judicial conscience that the extent of the complainant's wisdom in trying to rope in the victim of another rape case for 354 and 509 is based on 3 words in 3 paragraphs. So I have been summoned number 2 for intention to insult modesty. And then I have been summoned under 506, threat to cause injury if act omission done. Threat to cause injury, why they are trying to draw in is, my lord, the date of the alleged rape 13/2. I can't understand anywhere else. Or I release it in the media. Your reputation will be. So, my lord, whether given on the alleged overt acts of accused number 1 and accused number 3, should Aarti Rao number 2 face the consequence of a trial under 506 and 383. Is 384, but definition is 383. Putting person in fear of future. So one thing is clear from the complaint in my humble submission. R.P. Rao is nowhere present. R.P. Rao seems to be invoked as a mantra by the accused 1 and accused 3. And the complainant doesn't remember this from February 2010 till December 2010. Or chooses not to report it. Even before the CID in June 2010, I showed my lords the deed.
Is it not that if 120B, by any chance he stands proved against accused number 2, then automatically these 354, 506, 509, 383 also follow it?
Out of if it stands proved, the test here is, my lord, in my humble submission, going by the 3 paras where her name comes, if my lord feels that merely despite absence of, my lord, kindly see para 12 of the complaint. Why I'm saying it's all built in the air. Despite absence of CDs which are bought, cannot accuse me, even alleged to have shown her any. But a complaint has to, at the time of pleading, be summoning evidence. Whatever she saw orally or perceived with her senses, she deposes about it, like an attack, an assault, an attempted rape. The moment the complainant wants to step into the domain and need evidence and not go to the police and say that, sir, I was shown something, there is nothing to put the trial court. From where will the court get it? Who will get it? Even if I were to be summoned, I'm not talking about RP, I'm talking about Lenin Malad, accused number 1. Malad, from which thin air will this CD get produced? There had to be material before the magisterial court. Malad, 138 days. Let us take a case of a simple summoning. There is a check. If check is not there, Malad throws the case. Anything which is based on a document has to be proved by a document. Either you produce a photocopy, I don't know if even that would have met the test, Malad. That Malad, nowadays what is happening is not a complaints are coming. He sent me a dirty WhatsApp, so the lady produces the police. Then the police was in season. Nothing was done because the lady chose not to depose before the police in June 2000. So the question which Malad has put to me is, what if conspiracy is proved? My response to the Honorable Court is prima facie, even the basics of the complainant's case. So therefore, I draw Malad's attention only to para 12. Nothing seized by way of a laptop, photo, or video. The very basis of it. Second, there is nothing on record that anything was released in the media. Nothing on record. Kindly consider, it's very easy for the complainant to say, sir, it's released. Please go by the memory that TV mein kuch aaya. Nothing is there. There is no exhibit. Please see para 12. There is no exhibit. It's a brilliantly drafted complaint by brilliant lawyers. There is no CD as alleged in para 12. There is nothing on record that anything was released in the press. Because Malad rightly told me, like a 7-11, I have confined myself to the complaint. But when young members of the bar asked me what is 482, I said it's 7-11. You go by the FIR or the plea. So there is no newspaper report on record.
Do you mean to say that a private complaint under section 200 must be akin to a charge sheet?
Well, it's a private complaint. In fact, if Malad will see the recent judgment of the Honorable Supreme Court, where they distinguish between Sunil Bharti Mittal versus CBI, wherein Honorable Justice Dattu said, look, even a summoning order must be a speaking order. But that was the charge sheet case. Then came Vatiyar's judgment, wherein the Honorable Chief Justice said, oh, that test is only meant for private complaints because charge sheet is complete. Police does their investigation, material is there. It can even be a speaking order. So that finding in Sunil Bharti Mittal that you must give reasoning for each section. I did not come to it first because I know, my lord, as a trial court practitioner, unless I satisfy my lord's on facts, there has to be material. In fact, the burden is higher. The burden in a pre-summoning evidence case, in a private complaint case, is higher on the complainant because the state machinery is not involved and it will be a case of persecution. To avoid that persecution, our parliamentarians went in 202 a safeguard. I'll come to this. Allow me to just show to my lord paragraph 18 of mine. Because I'm only showing to my lord that there is a complaint before my lord. Neither the newspaper reporting is there, neither the CD is there, neither the mock papers are there. And please have paragraph 18 at page 26. This is most interesting. Probably this will appeal to my lord. That extortion requires delivery. Kindly see the last 4 lines on page 26. The complainant later learned that a sum of rupees 5 lakhs was obtained for her jewels from one Siva Vallabhaneni. Not a witness. This Siva Vallabhaneni is not a witness. There is no physical evidence and no statement of such obtaining of 5 lakhs. There is no proof of delivery. The complainant later learned that a sum of 5 lakhs was obtained for her jewels from one Siva Vallabhaneni, and the same was paid to the first accused. Again, please pay because they know she's not there. She'd show her passport. And my lord knows that recent judgment in the Swami's case, where Supreme Court says, my lords have the power to examine documents of sterling quality. Passport is one such one. I can't examine it. I deliberately did not come to it in the paper because I had placed my passport on record. The passport shows that from January to August 2010, I was in America. And I say I mean accused number 2, the lady Anna. This was to dilute her confidence to continue fighting for her. And as an officer of the court, I may say so, my lord, when state of Karnataka was not challenging the order the accused was getting, the complainant ran every time on 4 different locations. They wanted to dilute her confidence. In so many cases, she comes. So because my lord cannot look into all this, I have to show to my lord that the very basis of the case, what is the basis of the case? Extortion. How? Video was nothing. Basis of the case, telecast. Shown nothing. We believe oral testimony now for something which exists in something which is existing physically. Delivery, no proof. Nothing is there except evidence. Obviously, no receipt. They cannot be if they're claiming it's extortion. No proof, no message, no specific date. Apparently, no date also. Siva Vallabhaneni not examined. Further, my lord, paragraph 30, page 30. Paragraph 30, page 30, where they sum up their case, my lord. Somewhere 8 lines from the bottom. They have created a video, no video. But complainant can't do this. Complainant can't walk into court with the confidence that I utter something after 10 months orally. My lord, will bring to the Evidence Act. And merely on her own assertion. In fact, my lord, wiser by what my lord said. If a complainant goes to the police and her bare reading of the complaint makes out a cognizable offense, police has no choice but to register it. But that does not hold good for a magistrate. If a complainant goes before the magistrate, magistrate simply registers the complaint, tells her prove it. Please read your pre-summoning evidence. Have you filed a list of witnesses? Have you filed a list of documents? Are you sure it doesn't happen? But I'm saying, why did you not go for a 156? All your remedies would have been solved in a day. Because I show about a chart of 25 cases where police has filed reports. Similar followers of Swami have filed cases. The report has been filed by the DC report has been filed. What we in Delhi call closure, we don't call it DC. So again, the highest allegation in the air, thereafter started to blackmail the complainant to extort huge sums of money, have also received 5 lakhs. I showed Malad para 17. There is no proof of that 5 lakhs. Now, Malad will kindly have only 3-4 more pages. Unless my friend decides to read it, then I'll have to rebut. I don't want to come back to these facts again. Kindly have the pre-summoning evidence of the complainant. And page 32.
1 minute.
Malad, I hope, because Malad, read the file again and again. My endeavor to convince Malad is that can today, if a particular item is stolen from my wallet, will I go to the police or will I go to the learned and say, my friend has stolen it, please summon him? Judge will say. Judge will say. Judge will say, what is the proof? Why are you targeting him? Judge will say, why did you not go to the police? Can anybody be summoned like this? And that is what Pepsi says. A citizen being summoned, there is very serious consequences. Malad will remember that infamous case where in UP, the President of India was summoned. It was being taken so lightly in the process of summoning, and that is why amendments were brought in. I have placed judgments on record that the learned magistrate must be satisfied about the truth of the allegations. Now, I know what it is very big. The truth of the allegations. From how do I ascertain the truth if I am the magistrate? I will ask the lady. Question 1. Please produce the CD. She'll say, no, I don't have it. I would have directed this. Please produce the newspaper cutting. Sir, I don't have it. Direct the police. Please produce the telecast. Sir, I don't have it. Please produce Siva Vallabhai who says 5 lakh was sold. I don't have it. There is nothing, but I must be believed. Why? Because Malad, I choose to make a serious allegation of attempt to rape without physical injuries, without a scratch, no medical done. There is no medical on record, Malad. There is no tearing of fluids. There is not a scratch on the body. But we must accept. Now, Malad, we kindly have the pre-summoning evidence. I just draw Malad's attention to 1 or 2 pages, page 32. Page 32 of the pre-summoning. The relevant portion, Malad, will find at page 34. Malad, I don't know. I can speak for myself. I don't remember what my wife gave me to eat 1 week back. This lady remembers what happened 10 months back, and she even verbatim alleges every giving color to a movie. So please see what she says at page 34.
You remember probably what happened in your primary school day, any mischief committed by you, right?
I not remember the dates. It's very difficult. Human memory is very. I can say that somebody bullied me or somebody did a kind act. The teacher was kind to me. I can remember. Or some teacher was unkind. I can remember. I can't, Malad. Malad sees with Malad's vast wisdom on the session squad. Malad have seen when witnesses coming to the witness box. Why the machinery of police is involved? Because a man or a woman can't protect themselves. The state provides the machinery. The machinery is equipped to deal with it. Machinery is able to unearth evidence. That did not happen here. It is very strange. They don't go to the police at all. And in fact, when they go to the police, they keep quiet. There has to be a reason. They have to answer that. Why should I have to cross the barrier of a prima facie case in absence of all this material and face a trial as far as RPR is concerned? And if Malad decides to take that 202 is violated, then even then it would Malad get away. Because yes, there are allegations of intent. And the dilemma before honorable court and before a lawyer as an officer of the court is, what do we do? There is a prima facie allegation, even if it may not be proved, but should my client face a trial for 20 years? And I come to that at page 34.
Yes.
Page 34, Malad, at the top it starts December 2009.
Yes.
As there were Brahmotsav at Kanapeetham, I stayed for a longer period, for a period of 1 month in the ashram. During my stay at the ashram in the month of December 2009, whenever I used to walk in the ashram, accused number 1 started staring at me and standing near me. A couple of brahmacharinis noticed this conduct of accused number 1 with me and warned me to be careful about accused number 1, as accused number 1 was in the habit of taking photographs in his mobile. Again, no evidence. No brahmacharini produced, no evidence. We must accept her verbal statement in support what is supposed to be documentary evidence. Normally, my lord, private complaint mechanism was there for cases like 420. Documentary evidence which is in possession of the company.
No, that means you are expecting that, say, in the initial stage itself, the PCR must be exhaustive and it must be more than like a charge sheet, and all evidence what the witness or all the evidence what complaint intent to give in the trial has to be led first.
Because of the bar created under CH-8. Because ultimately, my lords, one is the practical side and one is the legislative intent. Now, my lord, we kindly have page 36.
You did not read anything in page 34. Give my attention to page 34.
Malas, I drew Malas' attention to page 34. I continue. Whenever Malas, during my state dash.
You are staring at me. I'm taking photograph in the mobile. Brahmacharan is not examined. So in the pre-summoning statement stage itself, the brahmacharinis also should be brought and examined, and they will be repeated during the trial.
No, I'm coming to the next slide. I'm coming to the next slide. Couple of brahmacharinis noticed this conduct of accused number 1 with me and warned me to be careful about number 1, as accused number 1 was in the habit of taking photographs in his mobile, and later on he replaced and washed their faces. But can this kind of allegation, even at a pre-summoning stage, in absence of any evidence, whereas I am only submitting one thing. Pre-summoning evidence for private complaints, where a person does not exhaust the remedy under 156(3), are actually meant for cases where already all the evidence is in the hands of the complainant. If all the evidence is not in the hands of the complainant, and the complainant decides to risk filing a complaint without that evidence, in my humble submission, the learned magistrate is bound in law to dismiss such a complaint. So, my lord, now I would only draw my attention to a violation which has already been filed on record. Before I do that, my lord, I had raised one technical objection on their petition. So, for that, please have my list of dates. Whereas in my list of dates, my lords will find there is a date 30th December 2010, which is the date of filing the present complaint which my lords were perusing. Then there is an order of taking cognizance on 31/12/10. That is a matter of record. Then there is a pre-summoning evidence which was left, which I took Mallard's through. Then the summoning order is there on 4/6/11. Now, Mallard, my learned friend's petition challenges this order of 4/6/11, where they want 376 read with 511 vote against Lenin or both. But what they have not challenged or amended the petition is the next order. 25/570. 25/570 is the order by the learned sessions court, wherein the order of the learned magistrate dated 4/6/11 came to be merged. That is subject matter of challenge in my petition. Having chosen or not having amended the petition and challenged 25/517 order, which affirms both ways. One, no 376 made up. For that, Mallard will have to take my petition. If Mallard wants to see 25/570.
6009.
6009, Mallard. As we'll find that at page 18, annexure P1. This order, my lord, affirms both ways. It says no, the summoning order was right on both counts. Kindly see, my lord. Page 28.
Yes.
Somewhere, my lord, in the middle. Accordingly,
Yes.
he has proceeded to issue process against these petitioners accused only for the offence punishable under 354/506, 384/509. Now, this order I have challenged. They have not challenged. So, my humble submission is that since the summoning order now stands merged into this particular order of the sessions court, their petition is in its present form, failing to challenge or amend the petition and challenging the order of 25/570. Their petition deserves to be rejected on that short ground alone. The doctrine of merger would clearly apply. The order of summoning does not stand alone anymore. It has merged into the sessions court order, and their petition, that is 763, ought to have been amended by them. This order ought to have been challenged.
We'll continue after lunch. You will be having another 10 minutes to conclude your argument.
Please.
Who may appear for the purpose of the petitioner that the final last opportunity at which time is granted, making it clear that no further adjournment will be granted in the matter. Is the matter on like 11? Yes.
May I make a submission, ma'am?
Yes.
With Lordship's kind permission.
Yes.
It's number 46.
Yes.
I request some accommodation.
Request of the for the petitioner. Next time as spread is granted as 5 minutes. Yes.
And again, there's
Court officer, court officer, court officer,
ಹೇಳಿ ಹೇಳಿ ಮೇಡಮ್.
ಸರ್ 46 ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೇಳಿತ್ತು, ಎಷ್ಟು ಕೊಟ್ರು ಅಂತ ಕೇಳಿಸ್ಲಿಲ್ಲ ಅದಕ್ಕೆ.
10 days ಮೇಡಮ್. 10 days.
ಓಕೆ ಸರ್, ಓಕೆ. ಸ್ಪೆಸಿಫಿಕ್ ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಲ್ವಾ ಸರ್?
ಸ್ಪೆಸಿಫಿಕ್ ಡೇಟ್ ಇಲ್ಲ ಮೇಡಮ್.
ಥ್ಯಾಂಕ್ ಯು ಸರ್.
Completely. Departments. Still number 42, my lord, was heard in part. There is a small question you want to make. Yes, the respondent wants to change his counsel. So the party himself is present there. He says he wants to change his counsel. That's why I'm mentioning. Still number 42. Almost completely heard, my lord. One question whether 138 can be compounded even without consent of was a question your lordship.
You are for the petitioner.
Yes, I'm.
He is respondent.
He is the.
You are ready for compromise.
Lord, I was always ready. Like I submitted before this one. But he
You are
was
ready
not-
for compromise.
Yes,
Earlier he was not ready.
yes.
Now is he ready?
No, my lord. He now what he says he wants to change his counsel.
Exactly, sir. Changing the counsel is another subject. Through his counsel on the previous occasion, he has submitted that he is not ready for
No,
compromise.
he was never ready.
He was never ready.
Never.
There is no purpose in granting any adjournment. ಅಲ್ಲಪ್ಪ ನೀವು ವಕೀಲರನ್ನ ಯಾಕೆ ಚೇಂಜ್ ಮಾಡ್ಕೊಳ್ಬೇಕು ಈಗ ಅವ್ರು ರಾಜಿ ಮಾಡ್ಕೊಳ್ತೀನಿ ಅಂದ್ರೆ ನೀವು ತಯಾರಿಲ್ಲ. You proceed. I don't grant time to him.
I'm ready.
Yes.
Pronouncement of orders. Serial number 50, Prasanna DP.
Dismiss. Revision petitioner is granted 45 days time to surrender. Yes.
Serial number 40. Archana KM. Javed S. Amkesh Quresh.
Sir, permitted me 10 minutes to make my submissions on law.
Conclude your argument.
Yes.
Hmm.
Kindly have to go to CRPC.
Yes.
Before I refer to the case law,
Yes.
may I only take Manoj to the provision?
Yes. You shall not take cognizance if he resides outside the.
Because the language is important and how it is being interpreted and provided I am covered in that.
Enquiry is ordered or report is obtained.
Any.
So far as Sessions Court judge's trial is concerned, whether it is applicable
Manoj,
in district sense.
here the summoning is by the magistrate.
Huh.
The summoning order went in revision to the Sessions Court.
Hmm.
So the provision of 202 will very much apply because the original summoning order is by the learned magistrate.
Hmm.
Kindly have 202. Any magistrate on receipt of a complaint of an offence of which he is authorized to take cognizance or which has been made over to him under section 190 may, if he thinks fit, and shall, I'm emphasizing on this shall, and shall, in a case where the accused is residing at a place beyond the area in which he exercises his jurisdiction, postpone the issue of process against the accused, and either inquire into the case himself or direct an investigation to be made by a police officer or by such other person as it is fit for the purposes of deciding whether or not there is sufficient ground for proceeding. So the key word is to, shall, and sufficient ground. Now, Manoj would kindly have the case laws. There is already a compilation on record, Manoj. If I may draw attention to only 3 pages of the compilation. Manoj may kindly have page 14. fact, I'll not waste this honorable court's time with 14. Manoj may directly have page 20. I have flagged it for Manoj's convenience. Page 20, paragraph 23.
Yes,
Abhijit Pawar versus Hemant Madhukar Nipalkar.
yes,
If I may read paragraph 23, Manoj.
yes,
Admitted position of law in law is that in those cases where the accused is residing at a place beyond the area in which the magistrate exercises his jurisdiction, it is mandatory on the part of the magistrate to conduct an inquiry or investigation before issuing the process. Section 202 of the Code of Criminal Procedure was amended in the year by the Code of Criminal Procedure Amendment Act 2005 with effect from 22 June 2006 by adding the words "and shall" in a case where the accused is residing at a place beyond the area in which he exercises his jurisdiction. There is a wide purpose for the objective behind this amendment, namely to ward off false complaints against such persons residing at a far off place in order to save them from unnecessary harassment. Thus, the amendment provision casts an obligation on the magistrate to conduct inquiry or direct investigation before issue of process so that are filtered and rejected. Now, Malad may kindly have page 34. That goes a step further. Page 34 bullets. Starts at 21. K.S. Joseph. Page 34, paragraph 6.
1 minute, please.
Please.
Page 34, Kiara.
Paragraph 6, Manoj, I am referring to placitum F.
Yes.
Only to emphasize a point, which on the writ side is very common, Malad, that reasons can't be filled in later. It must be reflected in the summoning order. So what the Honorable Supreme Court says, Malad says, the order sheet does not show. Malad has that line, placitum F. Para 6, placitum F. The order sheet does not show any application of mind to the fact that the accused was shown to be residing at a place beyond his jurisdiction and therefore an inquiry or investigation may be required. So what the Honorable Supreme Court says, it appears that it was not even present to the learned magistrate's mind. But even in my case, it's the same. There is nothing to suggest in the order taking cognizance or summoning that it was even present to the learned magistrate's mind that these accused persons are residing beyond the jurisdiction and therefore extra caution must be exercised. Kindly have paragraph 10, please. Para 7, Manoj, page 35. Paragraph 7, page 35. The amendment has a purpose in requiring the magistrate concerned to postpone the issue of process against the accused if he is residing at a place beyond the area of his jurisdiction and to hold an inquiry or direct an investigation by a police officer. Now, kindly have paragraph 10 minutes.
Yes.
I leave a line. We have already noted earlier that the order sheet does not disclose any application of mind either to the issue of delay or to the requirement of section 202. So my humble submission before Manoj is The very fact that the summoning order passed by the magistrate dated 4/6/2011 does not even show that the learned magistrate was aware that he had to comply with the provisions of 202 mandatory provisions. Note in the order that, look, I have recorded pre-summoning, but now I must ascertain in terms of 202 whether this is a vexatious complaint. And on this short ground alone, the Honorable Supreme Court sets aside the order and sends the matter back. This judgment somewhere goes against me also, because I learned one thing from my senior. There is no point, and it is in fact contempt in foreign courts to mislead the courts on judgments. So even if this line is against me, the fact of the matter is the order in question is silent. The learned magistrate followed, as we say, Rosmarra ki practice. The learned magistrate was probably not even fairly told by the counsel for the complainant that, sir, please be cautious. Your order might get challenged tomorrow. Please delay or defer the matter on the ground. You need to conduct an inquiry, because then the magistrate would have said, my God, I better be careful. There is something more which is required to be done. They don't do that. And that is what the Supreme Court is condemning. Now, last page, my lord, page 60. Relevant text 63. This is the most interesting judgment, my lord. In fact, the first judgment interpreting 202. Why I am referring it to last? Because I need a submission. That ascertainment of truth should be there. And my lord, smile, because in real life practice, it is not easy for a judge. But my lord, in Delhi, we are seeing judges have started asking questions. I was for the complainant, then the judge asked questions, then the complainant was demolished. So the truth came out. It's become common practice. Go in private complaint if you think the police is not guilty. Probably you can convince the judge or whatever. So please see page 62. This is the first judgment, National Bank of Oman, which actually deals with this amendment. Relevant at page 62.
As on the date of taking the cognizance,
4/6/2011.
this amendment was not there.
So it was there.
When it was taken,
2011 is the summoning order. So, Malad, kindly have page 60. I would obviously, Malad, wouldn't dare to argue of retrospective operation. It was very much there. And we have been successfully or partially successfully arguing it in courts, my lord's court or other courts. And there is a reason, my lord, because my lord knows half the cases which are filed are vindictive cases. Civil remedies are turned into criminal. Now, normally all this is done in 420 cases. The police is not supporting go in a 156 scheme, go in a private complaint. So please see page 60.
yes,
Paragraph 9, my lord.
yes,
The duty of a magistrate is, my lord, on the same page.
yes,
The duty of a magistrate receiving a complaint is set out in section 202 CRPC. And there is an obligation on the magistrate to find out if there is any matter which calls for investigation by a criminal court. The scope of inquiry under this section is restricted only to find out the truth. But that word truth is truth or otherwise of the allegations made in the complaint in order to determine whether process has to be issued or not. Investigation under 202 CRPC is different from investigation contemplated in section 156, as it is only for holding the magistrate to decide whether or not there is sufficient ground for him to proceed. The scope of inquiry under 202 is therefore limited to, they repeat this, no word is used by my lords or Supreme Court in vain. My lords use a word because that is the intendment of the word, for ascertainment of truth or falsehood. So 202 is there. The magistrate should have noted, oh my God, lady in America, man in Tamil Nadu, outside my jurisdiction.
Can you kindly elaborate on the point as to what is the ascertainment of truth
Truth, yes.
of the allegation?
Yes.
Is it not that the very purpose of the trial is the ascertainment of truth in allegation?
I
Ascertainment of truth in allegation means it is finding of a fact. If the fact is proven, he has to be pronounced guilty of the alleged offense. That is the job of the trial.
I'll try and answer that.
We should know at the beginning stage, is there any bona fide in making the allegation? Whether the allegation prima facie can be entertained with the court as a true allegation. Not a truth in the allegation. A true allegation and truth in the allegation are with ocean difference. A true allegation may lead to truth in allegation after the trial, or it may fall on its own. If it stands, conviction, no acquittal. That is the truth in the allegation. Whether an allegation is true, that is one thing. Truth in the allegation is a different thing.
So that test of truth, what Mallards have observed.
No, ascertainment of truth of the allegation.
I'll try and answer that. Mallard, this is only an effort to find the truth. This prima facie test is also an effort to find the truth. As one honorable judge said, the truth is only known to the parties. The judge is
Truth in what?
in what?
Yes, that is what I am asking. Attempt to find the truth. Fine. Attempt to find the truth in what?
That is
If
answer.
attempt is to find the truth in allegation, then trial is warranted.
I bow down to that. And therefore, before making my submission in response to what Mallard has said, allow me to show the last judgment in my compilation. That is a recent judgment, Birla Corporation, and how Mallards have interpreted it. And then we come to what is that prima facie truth? Because Mallard distinguished it. One is the magistrate supposed to cross-examine the witness and find out you are lying or speak the truth like a defense counsel? Or is the magistrate supposed to be on guard for all those persons who are sought to be brought in the jurisdiction outside the jurisdiction limit and asked 2-3 questions that look, say he showed you certain mob photos, you have it in your possession, she'd say no. Then what he'll do under 202? He'll direct the police to investigate. That power has been given, especially for people outside jurisdiction. 2, he'll say, madam, who say that June 10 made a statement before CID. Madam, can you produce that statement? Can you get a certificate? Allow me to see. Then the learned magistrate, because the learned magistrate is not in favor of or against anybody, my lord. It is not.
So you should have acted as a defense counsel to some extent in the beginning itself to filter the so-called allegation in truth to find out.
Well, may I say one thing?
To counsel. Use of the language, beautification of the language is one thing. Ascertaining what exactly the intention in a judgment and the intention of legislature is another thing.
Yes. So allow me to show Malad the last judgment.
Yes.
And then ultimately, Malad, we are in Malad's hands. Our job is only to assist the court in making it. This is the last judgment I'm giving because this was not legal. It was not published when that index was filed. Because I'm only referring to page 28.
Which judgment you rely upon among these three?
The Birla Corporation, the last one which I flagged, page 9 to 40.
But
I'm not touching on others. I don't want to burden the court with there must be proof of delivery. Even for summoning their Supreme Court has said there must be proof of delivery for extortion.
Basically, you are burdening the court in
No,
divisional jurisdiction.
Malad, may I say one thing? Malad, I am today in 482 before Malads. According to Prabhu Chawla, I need not go in divisional jurisdiction when Malad's 482 is there, which I have placed on record. Malad's powers under 482 are far beyond the divisional jurisdiction. Please have Malad page 20. Paragraph 30 minutes.
Let me see the opening page to know.
What is the opening page is at page 9. My lord, are referring to the first page of the judgment,
Yes.
page 9.
Always.
And I am seeking to draw my lord's attention to page 20. And in fact, my lord, I should even draw 28 since I don't want my lords to say I'm burdening the court. Please have page 34. They reaffirm Pepsi Food, and let us go back to what the celebrated judgment of Pepsi Food said about the summoning. That is the be and all of all judgments as far as summoning is concerned. Like Bhajan Lal is for washing. Please have page 30.
Page
30.
30.
It reaffirms Pepsi Food. So let us read, my lord, and then let me close my argument with
Yes.
para 34, my lord.
Yes.
In Pepsi Food, the Supreme Court has held that summoning of an accused in a criminal case is a serious matter, and that the order of the magistrate summoning the accused must reflect that he has applied his mind to the facts of the case and law governing the issue. I stop here. It is not there in this case. There is no reflection of mind. There is no reasoning. Summoning of an accused in a criminal case is a serious matter. Criminal law cannot be set into motion as a matter of course. It is not that the complainant has to bring only 2 witnesses to support his allegations in the complaint to have the criminal law set into motion. The order of the magistrate summoning the accused must reflect that he has applied his mind to the facts of the case and the law applicable thereto. He has to examine the nature of the allegations made in the complaint and the evidence, both oral and documentary, in support thereof, and would that be sufficient for the complainant to succeed in bringing charge home to the accused. It is not that the magistrate is a silent spectator at the time of recording of preliminary evidence before summoning of the accused. The magistrate has to carefully scrutinize the evidence brought on record and may even himself put questions to the complainant and his witnesses to elicit answers, to find out the truthfulness of the allegations and then examine if prima facie evidence is committed. My lord, my humble submission is it was a duty cast on the magistrate to first record in the summoning order of 4/6/2011 that look, now I am faced with a case where the accused is residing beyond the jurisdiction. I must stop my hands. A mere recording, a parent recording of the summoning evidence by 3 witnesses is not enough. Now I must see whether this lady's claim that somebody demanded bribe, whether that witness who claims that he got 5 lakh by putting the jewelry on hire, whether any documentary evidence is there or not, that would amount to a ascertainment of truth for a prima facie case, my lord. And also see, beyond saying that one talked about Aarti, what is there against Aarti? Should Aarti, as a victim of an offense of rape, be called to face a case of extortion and sexual assault, my lord, and attempted rape? But I am a defense counsel, I'll obviously feel for my client. But the fact of the matter is, there is already a chart before my lord as part of my main index, the last page, which shows 19 to 20 cases filed against me. Most of them have been interfered with. Either stay was granted by my lords in different jurisdictions or police filed closure reports. Therefore, they did not oppose the police. My lords, this has not been challenged till today. That index which is before my lord defined it at serial number 11, list of cases in that first index. It is there. Nobody challenged it even when the private counsels were coming and the amicus was not there because it was a matter of record. All I am saying is, my lord, it is a case where the ascertainment of truth test has not been done by the learned magistrate. The learned magistrate was not aware that he must hold his hands and he must not only follow the dictum of Pepsi Food. Pepsi Food is an old judgment. He must follow the law laid down by the parliament and he must ascertain whether he should summon Aarti and whether in absence of any documentary evidence, any medical evidence as to tearing of clothes or attempt to rape, any absence of evidence of extortion, should this entire complaint be allowed to proceed further. I'm obliged, brothers, and thank you for your patience.
Yes.
First and foremost thing I haven't the citations. I would go on my arguments on the citations later. Firstly, with respect to revision petition 763 of 2011, my lords, as my learned friend has pointed out that there has been no amendment, and post its order has been a part of the judgment in 25/5/2017, my lords. The criminal revision petition 763 of 2011, my lords. I was challenging the order dated 4/6/2011. As rightly pointed out by my learned friend, there has been no amendment, and as an amicus, I am my hands are tied, my lords. I can't amend those because 25/5/2017 dated judgment includes that order, the magistrate. Now, with respect to the new revision petition 6009 2017, no doubt an
Whether
amendment.
the session judge in the criminal revision petition instituted by them have stated that dropping the charges or the allegation with respect to the other offences which you have alleged against them is justifiable, or as that correct, or has he simply stated there is no error in the trial court, that is the magistrate taking cognizance for these 4 offences?
Oh, nothing is mentioned.
No, that last 3 sentences very clear in his order.
In my opinion, there are prima facie materials to register a case against accused 1 to 3 under section 354, 384, 506, 509, and there are no material regarding commission of offence under section 376, 511 and section 123 of IPC. That is all.
Yes.
In the revision petition 6009 of 2017 and 60. No doubt, an amendment of section 202 of CRPC makes it obligatory for the magistrate to hold an inquiry into the allegation of the complaint. What is the test taken by the magistrate under section 191A of CRPC, followed by section 204 of CRPC? It only reflects, my lord, that the magistrate has applied his mind to the facts. And
did you read the provision to section 202 CRPC?
Please. Postponement of issue of process. May I read, my lord?
Yes.
Any magistrate on receipt of a complaint of an offence of which he is authorized to take cognizance or which has been made over to him under section 192 may, if he thinks fit, and shall, in a case where the accused is residing at a place beyond the area in which he exercises jurisdiction, postpone the issue of process against the accused and either inquire into the case himself or direct an investigation to be made by the police officer or by such other person as he thinks fit for the purpose of deciding whether or not there are sufficient grounds for proceeding. A, provided that no such direction for investigation shall be made. A, where it appears to the magistrate that the offence complained of is triable exclusively by the Court of Sessions, or B, where the complaint has not been made by the court unless the complainant and the witness present, if any, have been examined on an oath under section 200. C, in an inquiry under
Leave
subsection.
that. Confined to this only. What is your submission now?
My submission before the lordship is, it is taken by the magistrate in section 191A of CRPC followed by 204, my lords. It only reflects that the magistrate has applied his mind to the facts of the case and he is satisfied that there are sufficient grounds for asking the person against whom the violation of law has been alleged to come before the court. It only means that the magistrate, satisfied with the facts alleged in the complaint, would constitute an offence which, followed by the sworn statements of the complaint and the witnesses, my lords, here, makes a prima facie case and makes the accused answerable to the court. My learned friend says there is no proof. But here, the magistrate is not accusing him to be a convict. They are answerable. They have been issued, processed, and taken cognizance to come and answer. How can that be a problem? Because no evidence. It's a matter of trial, my lords. And then what is important here is there is no speaking order or a formal order which is required to be passed. The lordship may kindly see only if a complaint is dismissed under section 203. Reasons are to be stated. That to brief.
So according to you, for taking cognizance, suffice for the magistrate if he says, peruse the complaint, take cognizance taken for the offences mentioned in the complaint. There ends the matter. Or cognizance taken, register in register 3, issue summons. That is sufficient.
No, ma'am. I stand. My only submission is there is no specific mode of inquiry at all. There is no specific mode of inquiry as to how this has to be done. If I will take your lordships to the Supreme Court citation, which says where it is not required. There is no specific mode managed. Where as soon as based on the complainants allegations in the complaint, then the magistrate is satisfied with the facts. Cognizance can be taken. There is no specific mode. Is my respectful submission. One of the application.
He is not on the point of mode. He did not canvass the argument that there is a specific mode and that mode ought to have been followed. What he said, the magistrate should have shown that he has applied his mind. For application of mind, what he ought to have done, basic minimum, which he did not do. That is what his summary of the argument.
Please, my lords. My lords, no law mandates that a magistrate has to arrive. Given the reasons there, my lords. Only when he is dismissing the complaint, the reason should be given, that too in brief. When cognizance is taken, no law mandates that the reasons have to be given. And there is no proper mode of inquiry is also mentioned. And the application of the mind is best demonstrated by the disclosure of the mind on satisfaction. Here, as per section 202 of CRPC, as I read, my lords, here the witness has been examined under section 200 of CRPC. And 202, if any witness, here as my lord also read out, there are 3 witnesses. So they have also been the examined. That is one. The option was there, and we have also followed that, is my respectful submission. So this exercise by the magistrate, my lords, to decide whether there are sufficient grounds or not for proceeding against the accused is nothing but an inquiry as per section 202 is my submission here. This exercise that the magistrate has gone through, whether to decide whether there are sufficient grounds itself is nothing but an inquiry under section 202, my lords. I would like to read out the Supreme Court citation, which clearly says there is no specific mode and how on.
There is no specific mode of taking cognizance.
Of inquiry. There's no specific mode for inquiry of taking cognizance. Please.
The magistrate should satisfy himself by application of his mind. He should show that he has applied his mind.
That
Of course, the point here is, according to him, magistrate has not shown that he has applied dismissal.
no law mandates. Let me learn it and show any section which the magistrate has to show the reasons in his order that he has applied. It is a discretionary relief. The magistrate will on the based on the allegations made in the complaint, if he is satisfied with the sworn statement of the complainant and the witnesses, he will take charge. It's a discretionary relief. It's a discretionary order. I would like to pass this Supreme Court citation.
Yes.
I will not trouble your lordships with more citations. This is the only citation which I am relying on. I highlighted the portions. If I may be permitted to read just the highlight. Every inquiry other than the trial conducted by the magistrate or the court is the inquiry. No specific mode or manner of inquiry is provided under section 202. In inquiry envisaged under section 202, witnesses are examined, whereas under section 200, examination of the complainant only is necessary with the option of examining witnesses present, if any. This exercise of magistrate for the purpose of deciding whether or not there is sufficient ground for proceeding against the accused is nothing but inquiry envisaged under section 202. In the present case, the magistrate examined the complaint on solemn affirmation of two witnesses, and only thereafter he has directed for issuance of processes. No merit in contention that magistrate not had inquiry as envisaged in section 202. No error in the improper. Which is very similar in our case. The complainant, along with witnesses, have been examined. Sworn statements are there. Further, at para 10, so I may take your lordship, paragraph 10 in the same chapter.
Yes.
3 lines from above.
Yes.
Thereafter, on the perusal of the allegations made in the complaint, the statement of the complainant on solemn affirmation and the witnesses examined, if any, various options are available to him. If he is satisfied that the allegations made in the complaint and the statements of the complainant on oath and the witnesses constitute an offense, he may direct for issuance of process as contemplated under section 204 of the code. Witnesses constitute, he may direct. Reasons code by paragraph 13. Again, the word inquiry has been defined under section 2G of the code, and the same is read as follows. Inquiry means inquiry other than a trial conducted under this code or by a magistrate. 14th paragraph. It is evident from the aforesaid provision, every inquiry other than a trial conducted by the magistrate court is an inquiry. No specific mode or manner of inquiry is provided under section 202 of the code. In the inquiry envisaged under section 202 of the code, the witnesses are examined, whereas under section 200 of the code, examination of the complainant only is necessary with the option of examining the witnesses present. This exercise of the magistrate for the purpose of deciding whether or not there is sufficient ground for proceeding against the accused is nothing but an inquiry envisaged under section 202 of the code. In the present case, as we have stated earlier, the magistrate has examined the complainant on solemn affirmation and the two witnesses, and only thereafter he is directed. Same is the case in ours. As my learned friend says, no torn clothes, no evidence. But on solemn affirmation, also the magistrate can take cognizance. This is my respective submission. But further, my learned friend went on to say that there has been delay in filing a complaint. In in February, the incident has occurred, and the complainant has waited for 8-9 months, 10 months to be precise. I would like to draw your lordship's attention to the complaint. She has, of course, stated her reasons why. I don't know how much that is relevant because this is a revision petition, my lord. The lordship would permit me, I will read. She gives detailed.
What is criminal revision petition? Yes or two criminal petition?
I would like to draw your lordship's attention. Paragraph 14, Manoj.
Yes.
The complainant, however, continued to suffer with immense pain and lost her ability to muster courage to take any action against the first accused for his powers and obnoxious acts of attempted rape and blackmail. She continued to suffer in silence due to the fear that the first accused had the extraordinary ability to morph the photographs, and in the event he published the same, her matrimonial relationship and firm film career would be devastated. Too many questions began to surface in the mind of the complainant. She began to wonder as to why the second accused, who is another devotee of Sri Nityananda Swami and who was the organizer of so and so, had colluded with the first accused to devastate her life. The complainant had never ever said or done anything that would have even remotely pained or hurt either of them. Further, my lords, at paragraph 29, the delay is explained again. 28 in the next chapter. 28. The 27. The acts of the accused completely shattered the marital life of the complainant besides her film career and the good work that she has done to the society in her personal capacity. And to respect.
1 minute, 1 minute.
Para 27.
Para
27.
Mixer of 27. That is the complaint, right? That is your file, right? Uh-huh. It's 6009.
Should appear at page 175 of 633. Page 170. Filed by the complainant, it appears to be missing on the court file, but in the query filed by me, it is at page 175. Extra G is the complaint.
24. 27, yes.
The acts of the accused has completely shattered the marital life of the complainant besides her film career and the good work that she had done to the society in her personal capacity and through respectable organizations and the fair name she had earned through her hard work and contribution to the society. All the professional work, social contribution, and personal life of the complainant is much beyond repair. On returning to India, she went through the write-ups, comments, articles, reports, etc. about her alleged scandal. The memoirs of first accused attempting to rape her and thereafter blackmailing her to extort money, and subsequent events of deeming the mock photo videos and publishing the name by print media started to haunt the complainant, and she once again slipped into depression and remained as a recluse. It took quite some time for the immediate family and friends of the complainant to help her out of the mental depression and give her courage to fight against the injustice caused by the accused. It was only after such counseling, strength and encouragement given to her by the family, friends, and well-wishers, the complainant decided to come out in the open to not only let the world know the truth and diabolic acts of the accused, but also to initiate criminal action against them for causing irreparable damage to her life and reputation. The delay is explained quite in this one, but only the relevant portion I have highlighted to your lordships. One another last. My learned friend kept on saying it's a counter blast only because she was found, allegedly, she was found in a compromising position. She has filed this. I would like to draw your lordship's attention to the complaint where she said from 2009, at paragraph 10, if your lordships kindly see. Paragraph 10, fourth line. During the month, paragraph 10, fourth line.
Yes.
During the month of December 2009, when Brahmotsavan festival was held, the first accused continued to pursue the complainant by unnecessarily coming, stationing himself near her and staring at her awkwardly. The efforts made by the complainant to avoid his presence seemed to worsen his desperation. He appeared to be thoroughly sick in the mind, and at that time the complainant was warned by few Ashramites who became aware of the intense attention of the first accused to put her and alerted the complainant that his favorite pastime of the first accused was to capture photographs of the brahmacharinis on his cell phone and to morph their faces and to replace it with photographs of celebrities and cine. In fact, few brahmacharinis who took offense to such conduct had even warned the first accused that they would complain about such conduct and perversion to the administrator. Whenever any Ashramite wanted to complain against his conduct, the first accused would profusely cry, seek forgiveness, to amend and reform himself. The brahmacharinis, being spiritual persons and known for forgiveness, have spared the first accused repeatedly, and the first accused with such acts had managed to evade the attention of the administrators of the Viharapeeth. So it is not that it's a fresh complaint as the counter as my learned friend used. No, but this has been, she had kept quiet. After undergoing work, after going through the incident attempted to rape, and after they filing a case against her allegedly in compromising, she has come out, nurtured courage, and filed this complaints against. One other thing, my lords, which my learned friend says that they were out. It is an admitted matter. The accused number 2 was not. But if you lordship can you see paragraph 17? It's all over the calls, extortion calls. I will. It's not that the accused number 2 was not at all a part of this. As my learned friend says that, I mean, almost to the extent that she's perfectly innocent. Whereas there's no smoke without fire, it goes. The saying goes, my lord. So here, she has taken up her name every now and then. Of course, maybe 3 times, yes. But the magistrate has the power by his solemn affirmation of the witness, only he can. There is no evidence here which is to be produced. So here in paragraph 17, only the relevant. My learned friend has missed this date, which I draw your lordship's attention. Paragraph 15 in the statement. The words of the first accused haunted the complainant, who began to panic at the thought of consequences that would follow if the event the accused released the photographs that were found in the laptop of the first accused and which had her shown to the complainant. She contemplated suicide and began to withdraw from others and started spending time in isolation. The complainant could no longer stay in Dhyanapetham and wanted to distract herself from the disturbing thoughts by engaging herself in her professional work and returned to Chennai. On 22/2010, while the complainant was in Kerala for a film shoot, she received a call from Nitya Parmananda, that is the accused number 1, from Dhyanapetham, stating that one Mr. Sridhar, the third accused herein, Nitya Parmananda, that from Dhyanapetham, stating that one Sridhar, the third accused herein, with a lawyer by profession and an accomplice of the first accused, had met them in Salem and had followed them to Ramnagar and displayed certain photographs of Sri Nityananda Swami said to be in a compromising position with the complainant, and had in return sought for the payment of the sum of rupees 20 crores to restrain them from releasing the photographs to the media, and that they insist on talking to the complainant on the phone. It's very clear that it is on the phone. The third accused then spoke to the complainant on phone and informed her that he wanted a sum of rupees 20 crores to restrain him, the first accused, and his associates from releasing. Here, one person is doing the talking, because when there is a main person, he doesn't do. There is a delegation, and that's exactly what has happened. The first accused has delegated another person to do it. However, that person has made a mention of the first accused releasing the photographs. Subsequently, associates from releasing the photographs that had been displayed by Lenin, that is the accused, first accused, to her earlier. He has also warned the complainant that he was in possession of much more material which the complainant could not even imagine, and further informed that his team would be present in Chennai on 23/2/2010 for further negotiations and hung up. So having said and done, my lords, some of my arguments, firstly, there is no specific mode of. Secondly, my lords, the first accused, second accused, and the third accused have attempted offences under section 504 to 354, 509 of the relevant sections are at section at the relevant paragraphs are again paragraph 12. It will be a repetition. I don't want to burden this lordship. The trial court, the impugned order, my lords. That's my only submission. The impugned order was right in taking cognizance of the offences and issuing process against the accused.
Yes.
For the respondent number, who is accused number 3. Allegation against the number 3, extortion. States para number 16, 17, and 18 got the allegation when against this accused. Yes, we have issued a call. First, was a demand. Yes. The same lots. She states in further para number 18 lots. Let some ornaments and paid for 5 lakh rupees. Further, she has stated that not the same was paid to first accused. Para number 18.
Yes.
It's made against me, Lord. Even the phone number is also not mentioned. Very importantly, at least you have provided a phone number. From this number, she had issued a call. So just mentioning the name of one R. Sridhar. The respondent number 3.
Yes.
And Lord, at panel number 16, Lord, 16. Somebody could no longer stay in Anapitham and wanted to protect herself from serving from us. by engaging herself in professional work written on so and so, was in Kerala for a film shoot. She received a call from Nitya Prananda from Anapita stating that one Sridhar, that is the third accused one,
Yes.
should have made call. Further note, who is a lawyer by profession and on occasion of the first accused and met them in Salem and had followed them to Ramnagar and displayed certain photographs. Here, not nowhere this accused has visited to Ramnagar.
Yes.
Check to in the compromising position with the complainant and had in return sought for a payment of sum of rupees to restrain from the releasing photograph to the media. And first instance, they state that they have made some file of this. Para number 17. Complainant continued to suffer with the thoughts of the consequences and inquiry with a couple of her friends who sympathized with her situation and expressed their anguish with informing her that she was dealing with professional blackmailers. The complainant then requested some of her friends who are lawyers by profession to meet the third accused with the guise of negotiation with the sole purpose of identifying his accomplices and persons who are all in possession of the mock photographs. Complainant has never seen the accused number 3 and never mentioned these names who are friends and lawyers who are inquired the respondent who are met the accused number 3. Accordingly, they met the third accused and during negotiation with him, the friends of the complainant expressed concern that unless all the conspirators were addressed at once, one among them or the other could release the pictures and unleash irreversible damage to the complainant. The third accused then informed that 2 others are involved in this issue and named them as the first and second accused and a prominent missionary and another person whose area was kept secret. He then promised to bring all the members of the conspiracy to Ramnagar. All this communication has done, place is not mentioned below. By saying the statement that he will bring all the conspirators into in Ramnagar, he said that the said act has not been Ramnagar. Even the extortion amount has been paid to the first accused. Not caused by the one could be not where human conspiracy is. Subsequently, all these sections will not follow next. Since I have not been involved in the said offense, I don't these sections not attracted to the accused number 3.
So for the petitioners in all the 3 petitions, including the learned amicus curiae and the learned counsel for the respondents, including for the respondents are present. Or further argument. Of learned, which is for both the parties. In full, including the reply argument. Not the 3 matters. Others reason.
Other matters. Still number 20. Case.
Sorry. Called again in the afternoon, the petitioner filed said, removes in conversion of this criminal revision petition into criminal petition. The registry also has raised an objection regarding the maintainability of this criminal revision petition. In the light of the above and in the light of the memo and supporting submission made from the learned counsel for the petition, justice is directed to convert this criminal revision petition into criminal petition. However, subject to the further scrutiny to be made by the registry in the criminal petition. Yes.
Number 27. Shravan Bharadwaj.
You have filed.
Notice.
Easy and bail through.
I think during trial was on.
No
Now, Lordship, please. Lordship,
serving sentence.
warrant, no, Lordship, warrant has been issued against him.
Called again, learned counsel for the petition is present, heard his submission. There was the memorandum of petition. A2 and 3 of 2020. Issue notice to the respondents, learned CH-8 takes notice for respondents and prays for a short accommodation. File his objections if any to A2 and 3 of 2022. It also submits that he would ascertain whether the accused is serving the sentence, who earlier was said to be on bail. a week's time is granted to the respondent to file their objections. Its objection in the pending legislation. Which the matter managed.
Serial number 30, Srimati Archana KM, J. Somsekhar. Yes. Called again in the afternoon. Amicus curiae for the petitioner, is counsel for the petitioner Sri J. Somsekhar and 11 CH-8 for the respondent. Present. Letter counsel Sri J. Somsekhar has filed in IA 3/2022. Seeking to recall the order dated 27/2022 when Amicus curiae was appointed for the petitioner in this matter. So the registry has raised an office objection regarding the provision of law mentioned in the application. However, in the submission of letter counsel for the applicant, he said office objection stands over. Pardon a year. About 20. The applicant, who is the learned counsel, has filed a memorandum of fact stating that on the study date of hearing, that was on 27/2022, since the petitioner did not contact him and did not give any instruction, neither himself nor his colleague could appear in the matter on the same day. And though the said reason is not convincing, however, considering the fact that the said learned counsel Sri J. Somsekhar was counsel appearing for the petitioner by filing wakalat, I am of the view that imposing some cost payable to the learned amicus curiae as honorarium, considering the effort put by her in preparing for addressing her argument in this matter, also time spent by her. The 3/22 be allowed accordingly, imposing the cost of 2,000 ರೂಪಾಯಿ ಕೊಡಿ. Cost of it is 2,000 payable by the petitioner to the learned amicus curiae, and also subject to the 11th counsel for the petitioner, proceeding further in addressing his argument on the main matter. Today itself, a 3 stands alone. Next line, Learned amicus curiae acknowledges the receipt of the charge. Amicus curiae, Srimati K. Marchana, is permitted to, is relieved from appearing for the petitioner in this matter. Learned Sri J. Somashekara is permitted to continue to appear for the petition in the matter. Yes, proceed with the matter. Yes.
Current finding of the DMFC and also the session of Hassan. The accused was convicted with section 7, 1 and 2, section 16 of the Prevention of Adulteration Act 1954. Getting him to undergo SI for 6 months and fine up to 1,000. Default to undergo SI for 2 days. Because it's fine. Yes, of the prosecution is that
Section 7. Yes.
The case of prosecution is that on 26/2008 at Ajad Road, at Westwood, when the complaint along with his staff were on duty, this time visited the top of that was at 5 p.m. He suspected that the accused was found storing and selling the disparaging adulterated coffee powder in his shop. The alleged purchased 600 grams of that is 200 grams of 3 packets of the coffee powder for purpose of analysis by the public health care. Then he issued a notice to the accused in form number 6 regarding his intention to have it so analyzed to the from whom he has taken the sample. There is no evidence to show that Interim has complied the provisions of section 11A of the Commission Food Regulation Act. The mandate is not to obtain your signature of the accused under section 7B of the Prevention of Food Regulation mandate. He used to draw the margin in the presence of the witnesses. Those witnesses have not been examined through trial. He sent the sample in public announced on 21/6/2008 to the Division Public Analyst Mysumena. On 19/8/2008, the complaint received the certificate in form number 3 from the local, that is the head Health Authority and the Taluk Health Officer, Sakleshpur, as per Exhibit E9, that is the report of the chemical examiner, which has been issued by the regional public analyst from regional assistant chemical examiner Mysore. He opined that coffee powder alleged to have it seized from the is adulterated and also misbranded. After obtaining the written consent, the section 20 of the Act manner from the district health officer to prosecute the accused, that is sanction order section 10 as exhibit P10 manner. The sanctioning of the permission is very illegal because we come to the later because we have not gold is additional seized from the accused, not adulterated. I will into the lordship later. Then after we filed a charge sheet before the judicial magistrate. The prosecution has examined 4 witnesses. That is the complainant is Peter 1 is the complainant, and Peter 2, Nagaraj Rao, who according to permission the health officer, who according permission to prosecute the case. Exhibit P1 is his permission. He has been cross-examined and he has not been cross-examined in the council of the accused before the trial court. The Peter 2, without looking to the actual report of the commission, technical report, and examine the provision of the law, he has mechanically accorded permission. He mechanically accorded permission to prosecute the case. Later, come to the what is that is exhibit E9 is the chemical report. Exhibit E9 is the chemical analysis report. According to chemical analysis report, the contents of coffee is 0.4%. The permission limit is not less than.
What are your points of arguments, please? Can you tell them one after another? You can elaborate them later.
That even this powder has been seized by the complaint from the shop of the accused. This is not adulterated coffee powder because lordship.
What is it?
Adulteration Act.
I have. What are your points of argument? First, highlight the points of argument. Later, you can explain them.
This is the exhibit P9. P9. That is a report of the public analysis. According to him, that is the next parameter. That is the NDC. The quality of character. That is there, man. That is the total ash. That is a 2.20%. That is not more than that. That is the permissible quality. Ash soluble 2% melon and caffeine milk 4%, not less than 6%, and aqua 5.5%. 5%. That is actually permission limit is 5%. When we see the section 2. Section 2 melon, section 2, 1A is the adulterated. B is our that our case is for an email. If the articles contain
Section
1A.
1 minute. Yes.
3, my lord, if the articles contain any other substance which affects or if articles is processed as to affect injuries to the nature, substances or quality thereof is adulterated.
One minute. 1 minute. Yes, please.
Permitted to draw the attention of the lordship. Section 2L, my lord. 2L, my lord.
According to trial court and the sessions court, your alleged act falls within which section of the act?
Section 6.
No. According to trial court and the session judges court,
Both,
your offense is under which section, subsection, clause, subclause of the act?
7(1), my lord. 7(1) and 2. 7(1) and 2. That is the punishment part. Section 16 is the punishment part. Section 7 is the 11. The 7 says 7(1) says adulteration and 2 says any adulteration.
Misbranded.
And both charges are inducted in both courts. Because main condition is income hardship is that even assuming that the powder has been seized from the shop owner, this is not adulterated with coffee powder soap seized from my position. Or not adulterated. Because of because it was not introduced to the health. That is the one. That is the subsection M says like.
1 minute. That is the reason I asked you. What is the observation of trial court and the sessions court? Under which subsection, which clause of section 2 your act falls?
So there is no such observation. Any of the I have read the judgment of both court mechanically because it was upheld by the trial court. The permission was but the observation of the trial judge is that because of the complaint is the public servant, there is no illegal against the accused, and there is no chances of filing the complaint. Because if the both court want to have consider the section whether the branded, even the branded and the powder seized from portion of the accused is adulterated. I don't the section says that it is not injured, it is not adulterated. The letter magistrate has not because yes, he has not recorded because since he is the government servant, he need a complaint with the government servant, he need not record his statement.
Whether the trial court and the sessions court have not discussed or not reasoned as to under which subsection or clause of section 2 your act falls.
They are not stated. Physical examiner also was not subjected for though my application was allowed. You are not summoned and permission accorded to the opportunity was given to the accused to cross-examine the chemical examination. The court to examine the chemical report, the trial court would not have taken cognizance of the submission. Trial court has observed, considered, look into the chemical report, and also provision of section 2. They could at the stage of cognitive itself, they could have rejected the. This is the application. However, the chemical report says that the content so found observed the injuries to the health. That is the section says. If not injuries to the health, then they will come out the adulterated food as per section 2L and M. 2L and M. Ingredients are there in this coffee powder, one coffee powder and also chicory. Chicory content of chicory as per permissible quantity is 6%. But the chicory found in this report, this powder, less than 4%. That is why the chemical examiner report examiners opined that it is adulterated food. And also the percentage of water content, the was little more, that is 5%. Permissible quantity is 50%. Not injurious to health. That should be the injurious to health that is amounts to adulteration. Otherwise not. It is provision of section 2, madam. Provision of section 2 of the Act.
Is it that in case like this, the content must be necessarily injurious to health, only then it can be called as adulterated?
Because 7.1 says adulterated. Because
My question is that whether to call a goods or a food as adulterated, whether it must be necessarily injurious to health.
because of the very problem, it is not injurious to health, madam. It is not amount to adulterated. There is the provision thing. The provision to section 2 of the.
So according to you, to say that a food is adulterated, it must be necessarily injurious to health.
Not my condition. The contents own is the powder, madam. That is the percentage of the that is less than 4%, and the upper of the water content is it is beyond the permissible limit, madam. But the provision says it is not injurious to health.
Sir, that's what I'm asking
Yes,
you.
madam. That-
Whether to call a food item as an adulterated, whether the food item must be necessarily injurious to health. If it is not injurious to health, do you want to say that it is not adulterated? ನೀವು ನನ್ನ ಪ್ರಶ್ನೆಗೆ ನೇರ ಉತ್ತರ ಕೊಡದಾರೆ ಕೊಡಿ ವಕೀಲ್ರೆ, ಇಲ್ಲರೆ ನಾನು ತಿಳಿದಿದ್ದು ಬರ್ಕೊಂಡು ಹೋಗ್ತೇನೆ. 5ನೇ ಸರ್ತಿ ಕೇಳ್ತಿದ್ದೇನೆ ಆ ಪ್ರಶ್ನೆ.
But in the subsection says, says that permit case.
ಓದಿ,
Yes, sir.
ನಾವು ಓದಿದೆ, ನಿಮ್ಗೆ ಓದ್ಕೊಳ್ಳಿ.
Yes, sir. The provision that is one.
ಓದಿ.
When one of the article has fallen below the prescribed standard or its constitutes or present in the quantities not within the prescribed limit of the variable or in either case solely due to natural causes. It is the condition, natural causes and beyond the control of human agencies, then such an article shall not be deemed to be adulterated within the meaning of subsection. Because I received coffee seeds from the customer. I get it roasted and I will prepare the powder and given to the customer. Because the mine is very small shop. Because I have got one small roasted machine and also powder machine. Because environment. Because he does not know whether the seeds contain more fat or because he mixed the scoring and the customers want to mix the scoring and that should be permissible for quantity. But this in this case, the scoring contains sugar 4%. That permission not less than 6%. That is even less than 6%. That's less than 6%. 6 is the standard permissible quantity, but it's less percentage. When you see the it will be 9. But that is water content of powder. 5% is not increased that. Does not amount to adulterated. Primary food and Israeli something. Primary food and Israeli. We contribute to this section. So it's primary food.
ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಪ್ರೈಮರಿ ಫುಡ್ ಅಂದ್ರೆ ಏನು ಅಂತ?
Food. 4 minutes. Section. Chapter. Roman 6 minutes. Food.
So whether your article a coffee powder be considered as a primary food?
Because of primary food definition.
Whether coffee powder comes under primary food? Whether coffee powder comes under primary food? According to you, yes. Read the definition of primary food.
Two.
212A.
Primary food means any article of food being product of agriculture and article in this nature form. So this is the agriculture. So the coffee as per the income tax act, agriculture product.
Don't attract income tax. This act is self-sufficient.
Yes, sir. Coffee is the agriculture product.
Coffee seeds are agricultural product.
Agriculture product.
Coffee seeds. Coffee powder.
Coffee seeds. Because it's made out of coffee powder.
Coffee seeds are agricultural product. Coffee powder.
Made out of.
So ಬಿಸಿಬೇಳೆಬಾತ್ ಪೌಡರ್ ಕೂಡ ನಿಮಗೆ ಪ್ರೈಮರಿ ಫುಡ್. ಯಾಕಂದ್ರೆ ಅದರಲ್ಲಿ ಇಂಗ್ರೀಡಿಯೆಂಟ್ ಹಾಕಿರೋದು ಎಲ್ಲದನ್ನು ಕೂಡ ಕೃಷಿಯಿಂದ ಬೆಳೆದದನ್ನ ಹಾಕಿರ್ತಾರೆ. ಉದ್ದಿನ ಬೇಳೆ, ಕಡಲೆ ಬೇಳೆ, ತೊಗರಿ ಬೇಳೆ, ಸಾಸಿವೆ, ಜೀರಿಗೆ.
ಅದನ್ನು ಅಷ್ಟೇ ಚಿಕ್ಕೋಡಿ is also grown in agriculture. ಅದು ಪ್ರೈಮರಿ ಫುಡ್ ಬಿಕಾಸ್ ಫುಡ್ ಅಂಡ್ ಸೇಫ್ಟಿ ಆಕ್ಟ್ ಅಲ್ಲೂ ಇದೆ ಸರ್. ಏನು ಇದು ಪ್ರೈಮರಿ ಫುಡ್ ಅಂತ ಏನು ಅಂತ ಫುಡ್ ಸೇಫ್ಟಿ ಅಂಡ್ ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಆಕ್ಟ್ ನಲ್ಲಿ ಅದರಲ್ಲೂ ಹೇಳ್ತಾರೆ.
ಡೆಫಿನೇಷನ್ ಇನ್ನೊಮ್ಮೆ ಪೂರ್ತಿ ಓದ್ರಿ. ಡೋಂಟ್ ಬಿ ಹೇಸ್ಟಿ. ಆ ಡೆಫಿನೇಷನ್ ಆಫ್ ಪ್ರೈಮರಿ ಫುಡ್ ಓದಿ ಇನ್ನೊಮ್ಮೆ.
ಪ್ರೈಮರಿ ಫುಡ್ ಎನಿ ಆರ್ಟಿಕಲ್ ಆಫ್ ಫುಡ್ ಪ್ರಾಡಕ್ಟ್ ಆಫ್
being a product ಅಲ್ಲ. ಪ್ರೊಡ್ಯೂಸ್ ಗೂ ಪ್ರಾಡಕ್ಟ್ ಗೂ ಬಹಳ ಡಿಫರೆನ್ಸ್ ಇದೆ. ನೋಡಿ ಕರೆಕ್ಟ್ ಓದಿ. ಇನ್ನಿಟ್ಸ್ ಇನ್ನಿಟ್ಸ್ ನೇಚರ್ ಬೇರೆ, ನ್ಯಾಚುರಲ್ ಫಾರ್ಮ್ ಬೇರೆ. ಯಾಕೆ ನೀವು ವಕೀಲರಾಗಿ ಎಲ್ಲ ಪದಗಳನ್ನು ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ಕೊಳ್ತೀರಿ? ಹೌದು. ಈಗ ಕಾಫಿ ಪುಡಿ is it an agricultural produce in its natural form? ಇಲ್ಲ ಅಲ್ವೇ? ಹಾಗಾದ್ರೆ ಪ್ರೈಮರಿ ಫುಡ್ ಅಲ್ಲ. ನೀವೇ ಹೇಳಿದ್ರಲ್ಲ ಅಲ್ಲ ಅಂತ. ಈಗ
ಕಮಿಷನ್ ಮಾಡಿ adulteration is not adulteration is so
adulteration, whether adulteration must be of primary food only or is it of food?
any food because
So it may be of any food, not necessarily primary food, right? So coffee powder may fall into definition of food, not primary food as you contend.
is that because it is a product of agriculture and out of seeds get converted, then
Swami, ಆಲೂಗಡ್ಡೆ ನ್ಯಾಚುರಲ್ ಫುಡ್ ಹಾಗೆ ತಿಂದ್ರೆ, ಶಿಫ್ಟ್ ಮಾಡಿ ತಿಂದ್ರೆ ನ್ಯಾಚುರಲ್ ಫುಡ್ ಅಲ್ಲ, ಅದು ಪ್ರೈಮರಿ ಫುಡ್ ಅಲ್ಲ. ನೀವು ಲೇಸ್ ಚಿಪ್ಸ್ ತಿಂದ್ರೆ ಪ್ರೈಮರಿ ಫುಡ್ ಆಗಲ್ಲ. ಆಲೂಗಡ್ಡೆನೆ ಬಾಯಿ ಹಾಕಿದ್ರೆ ಪ್ರೈಮರಿ ಫುಡ್. ಆಲೂಗಡ್ಡೆ ವ್ಯಾಪಾರಿ ಪ್ರೈಮರಿ ಫುಡ್, ಲೇಸ್ ಚಿಪ್ಸ್ ವ್ಯಾಪಾರಿ ಪ್ರೈಮರಿ ಫುಡ್ ಅಲ್ಲ. ಅವನು ಲೇಸ್ ಜೊತೆಗೆ ಬೇರೆ ಯಾವ್ದೋ ಪಾರ್ಲೆ ಚಿಪ್ಸ್ ಮಿಕ್ಸ್ ಮಾಡಿದ ಅಂದ್ರೆ ಫುಡ್ ಅಡಲ್ಟ್ರೇಷನ್ ಆಕ್ಟ್ ಅಲ್ಲಿ ಬರ್ತಾನೆ ಅವನು, ಅಡಲ್ಟರಿಂಗ್ ದಿ ಫುಡ್ ಅಂತ. ಫುಡ್ ಹೌದು, ಈಗ ಫುಡ್ ಅಲ್ಲ ಅಂದಿದ್ಯಾರು? ಫುಡ್ ಅಲ್ಲಿ ಬರುತ್ತೆ, ಹೌದ್ರಿ, ಫುಡ್ ಅಲ್ಲಿ ಬರ್ತದೆ, ಮನುಷ್ಯ ಅನ್ನೋದ್ರಲ್ಲಿ ಬರ್ತದೆ. ಅದು ಹುಡುಗನ ಹುಡುಗಿನ ಅನ್ನೋದು ಪ್ರಶ್ನೆ. ಹ್ಮ್
ಡೆಫಿನೇಷನ್ ಸ್ವಾಮಿ ಎರಡು ಮತ್ತು ಎಮ್ಮಲ್ಲಿ ಎರಡು ಡೆಫಿನೇಷನ್ ಬಂದಿದೆ. ಮತ್ತೆ ಪ್ರಾವಿಷನ್ ಬಂದ್ರೆ ನಾಟ್ ಇಂಡಿವಿಜುವಲ್ ಟು ಹೆಲ್ಪ್ not induced as well. Not adulterated. I cannot be convicted on section 7(1). It may happen. They must prosecution must establish the adulterated. Adulterated because it's a quality. This one contents of traffic less. And the water content is little more, which is not induced. It is not the case of the prosecution. The condition of the accused under section 77(1), subsection 1, it is section 16 improper.
Yes.
That misbranded method. Misbranded. That is section 2. But I was also convicted in section 2(7)(2) method. Misbranded is defined in section 2(7) method. Same method. Let us see exhibit P5 element. Exhibit P5. Let us go there one document. Yes, madam. It is P. Because of it says
Exhibit P4 or exhibit P5?
That is far number 6. 6. That is details of food milk. Coffee powder 600 grams. Date DO payment. Date of production 26/2008. DPN batch before 6 months only use ಮಾಡಬೇಕು. Batch number 1 ಅಂತ. Manufactured by Select Coffee Works, Adas Road, Sakleshpura. Code number 81/613. Kindly see the exhibit P9. That is the chemical examiner report method. So he opined because it was not mentioned whether it is vegetarian or non-vegetarian on the pocket, it is a misbranded according to me. First page in the other satisfactory. Collection copy works Ajad Road, Sakleshpura, on 6/8 ಇದೆ. Batch number not printed. Small shop owner, not printed, it is handwritten. That is it. It is key name. First page. Just before not printed, it is handwritten. But non-veg, not printed on the package. I'll powder impliedly because you purchaser can say.
So what is their allegation regarding the misbranding?
According to him, my lord.
What, according to the charge sheet, what is the alleged adulteration and alleged misbranding? There are varieties of adulteration, varieties of misbranding,
Because
which you have been.
According to complainant, because it was not printed, the batch number is not printed, and the best before is also not printed, and whether it is veg or non-veg is not printed. It is the amount according to him, according to.
From what you are reading that?
Except P9 and or a chemical exam report, here is examined.
Exhibit P9 is the chemical examiner's report or public analyst report. I am asking you the allegation made against you. What is that allegation regarding the food adulteration? What is the allegation regarding the misbranding?
They have done the report of this one, chemical exam.
ನನ್ನ ಪ್ರಶ್ನೆ ನಿಮ್ಗೆ ಅರ್ಥ ಆದ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ, ಇಲ್ಲ ಅಮಿಕಸ್ ಕ್ಯೂರಿಯನ್ನ ಮತ್ತೆ ನಾನು ಕರೆಸ್ತೇನೆ.
Complaint to very head.
16 ವೆರೈಟಿಯ ಮಿಸ್ಬ್ರಾಂಡಿಂಗ್ ಇದೆ, 16 ವೆರೈಟಿ ಅಡಲ್ಟ್ರೇಷನ್ ಇದೆ. ನಿಮ್ಮ ಮೇಲೆ ಇರ್ತಕ್ಕಂಥ ಅಲಿಗೇಷನ್, ಸ್ಪೆಸಿಫಿಕ್ ಅಲಿಗೇಷನ್ ಏನು?
Complaint.
ಏನ್ ತಗೊಂಡ್ರಿ?
From appearing for the petitioner.
But the argument of learned counsel for the petitioners is based on Somshekar in part for his further argument, followed by respondent's argument and reply. It's the matter on 4:11. Yes.
Till number 35. Vintesha Mouni, KM, CGP for respondent.
Yes. Iskoli.
Appear for the petitioner.
Hmm.
Petitioner was right.
Was during the appeal, was he on bail?
Yes, Manoj, he was on the bail.
No.
Now Manoj is in custody, Manoj, from the date of judgment 2011-2021, he is in custody.
From which day?
2011-2021.
Nearly 1 year. How many days?
19 days short for 1 20, 11, 21.
Ah.
Now it's 2, 11.
Since when he is in judicial custody? Is he in judicial custody? If so, since when?
Possibly.
It is for you to ascertain and make submission. You have not mentioned that in your statement of objection.
With regard to the post conviction, that is the different criteria. There are 10.
Post conviction, he did not approach the court immediately.
I got 21.
Was there any delay in filing this appeal? You won't agree. To ascertain the correct date when he was arrested and serving the sentence. Called again, Learned Counsel from both sides present and CH-8 filed the statement of objection. So by 2/2022, duly serving copy thereof to the Learned Counsel for the petition. When the court asked the question as to since how long the CH-8 undertakes to ascertain as to since how long the petitioner is in judicial custody serving the sentence. It's the matter on 4/11. Second event.
Scene number 39. CSM Shivviraya, Srimati SB Lakshmi.
Number
39.
right? The respondent is not ready for settlement. Respondent has informed he is not ready for settlement.
Respondent is not ready for settlement. So your amount of alleged 5 lakh is not acceptable to them. Fine amount is 18 lakh rupees, 18.5 lakh. ಮತ್ತೆ 18 ಲಕ್ಷ ಬರೀ 5 ಲಕ್ಷ ಕೊಡ್ತೀನಿ ಅಂದ್ರೆ ಅವ್ರು ಯಾಕೆ ಒಪ್ತಾರೆ?
Initially,
ಹ್ಮ್
offer ಮಾಡಿದ್ರು.
ಹ್ಮ್
Now he has changed his version.
But again, there are counsel from both sides present. Both sides submit that the settlement could not be arrived at between the parties in the matter. And the matter has to be proceeded in the argument. Since the court time is over, which the matter. The second, first ಕೊಟ್ಟಿದ್ದು ಕಾಪಿ ಕೊಡೋದು 411 ಇದೆಯಲ್ಲ, ಟಾಪ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ಆಯ್ತು. ಇದು ಸೆಕೆಂಡ್ ಟಾಪ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ 411. ಇದು ಫೈಲ್ ಕಳಿಸಿ. ಹ್ಮ್ Which one? ನಾನು ಫೈನಲ್ ಡಿಸ್ಪೋಸಲ್ಗೆ ತಗೊಳ್ತಿದ್ದೇನೆ ಅದು. ನೆಕ್ಸ್ಟ್ 41 ಇಲ್ಲ. ಸರಿ.
Case number 41, case of A, CGP for R1. Respondent for R2.
ನೋಟ್ಸ್ ಇದೆಯಾ ನೋಡಿ ಇದರಲ್ಲಿ? ಇಲ್ಲ. Yes, please.
Rather than that. But of the maintainability that this petition is concerned, my lord. This case, my lord, what happened, my lord, the trial.
The state's appeal was dismissed. The complainant has come because the state lost.
State has not preferred any appeal, revision before this court. In this case, my lord, against the total of this respondent, my lord, the complainant has not preferred any appeal before this success court or before this.
State had filed.
State has preferred. But in this case, my lord, complainant has filed the revision directly before this honorable court.
Is it barred?
As complainant is concerned, my lord, cannot challenge the agreement, the revision because my lord, he has not challenged.
ತೋರಿಸಿ ನೀವು ನನಗೆ ತೋರಿಸಿ ನಾಟ್ ಮೈಂಟೈನಬಲ್ ಅನ್ನೋದನ್ನ ತೋರಿಸಿ ನೀವು ಓರಲ್ಲಿ ಹೇಳ್ತಿದ್ದೀರಿ ಶೋ ಮೀ ಸಮ್ ಸೆಕ್ಷನ್ ಆರ್ ಶೋ ಮೀ ಸಮ್ ಸೈಟೇಷನ್
Regarding maintainability, in 2014, officers.
It was heard.
Objection, my lord.
Ah.
That was overruled after our submission.
The office objection of maintaining your revision petition by complainant of the maintainability of the revision petition.
By complainant. By complainant.
No, did they say that revision is not maintainable, appeal is maintainable ಅಂದ್ರೆ ಅವರು ಯಾವ ಡೇಟ್ ಹೇಳಿ ಯಾವಾಗ ಅದು ಓವರ್ ರೂಲ್ ಆಗಿದೆ ಏನ್ ಅಬ್ಜೆಕ್ಷನ್ ನೋಡುವ ಇಲ್ಲೇ ಇದೆ ಆರ್ಡರ್ ಶೀಟ್
24 to 2014. Overruled.
What was the office objection which was overruled?
ಅದು not maintainable ಅಂತ ಇರೋದು overrule ಮಾಡಿದ್ದಾರೆ.
Not maintainable not maintainable because the complainant has filed this not by the state anta agiralla samanya. You have come against the judgment of acquittal. Therefore, revision petition is not maintainable. It is the appeal that is maintainable anta helirtare. Overrule agidru ಆ ಪಾಯಿಂಟ್ ಮೇಲೆ maintainability ಮೇಲೆ ಆಗಿರುತ್ತೆ. ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಬೇರೆ ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಸ್ಟೇಟೇ ಅಪೀಲ್ ಬಂದಿದ್ರೆ ಅಥವಾ ಸ್ಟೇಟೇ ರಿವಿಷನ್ ಬಂದಿದ್ರೆ ಬೇರೆ ಪ್ರಶ್ನೆ. ಸ್ಟೇಟ್ ಬಂದಿಲ್ಲ, ನೀವು ಬಂದಿದ್ದೀರಿ. ನೀವು ಕೆಳಗಡೆ ಕೋರ್ಟಿನಲ್ಲಿ ನೀವು ಅಪೀಲ್ ಹೋಗ್ಲಿಲ್ಲ, ಈಗ ನೀವು ಬರಲಿಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ ಅಂತಾರೆ. ಏನಂತೀರಿ?
ಅದು maintainable. Got one judgment, recent judgment of Supreme Court.
ಏನಂತ ಹೇಳುತ್ತೆ?
ಅದರಲ್ಲಿ ಇದು ಕಂಪ್ಲೇಂಟ್ ಕೂಡ revision petition file ಮಾಡಬಹುದು ಅಂತ.
Against the order of acquittal where he has not filed appeal.
Against any order ಅಂತ ಇದೆ.
ಇಸ್ಕೊಳ್ಳಿದೆ ಅದು. This is totally different judgment you are relying upon. ಕೋರ್ಟ್ ಓದ್ಕೊಂಡು ಬರ್ಬೇಕು, ಅದು ಬರೀ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಓದಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳಿದೆ ಅಂತ ಹೇಳಿ ಹೈಕೋರ್ಟ್ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡಿದ್ರೆ ಪೆನಾಲ್ಟಿ ಹಾಕ್ತೇನೆ, ನಾನು ಹೆವಿ ಪೆನಾಲ್ಟಿ ಹಾಕ್ತೇನೆ. ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಸ್ವಲ್ಪ ಹೆಚ್ಚಿನ ಜವಾಬ್ದಾರಿ ತಗೊಳ್ಬೇಕು ವಕೀಲರು, ಬಹಳ ಕ್ಯಾಶುವಲ್ ಆಗಿರಬಾರ್ದು. ದಿಸ್ ಜಜ್ಮೆಂಟ್ ಇಸ್ ನಾಟ್ ಅಪ್ಲಿಕಬಲ್. ಇದರಲ್ಲಿ ಒಂದು ಇಂಟರ್ಲಾಕ್ಯುಟರಿ ಆರ್ಡರ್ ಮೇಲೆ ಕಂಪ್ಲೇನೆಂಟ್ ವೆಂಟ್ ಟು ದಿ ಹೈಕೋರ್ಟ್ ಡೈರೆಕ್ಟ್ಲಿ ಅಂಡರ್ ಕ್ರಿಮಿನಲ್ ರಿವಿಷನ್ ಪಿಟಿಷನ್, not on the final judgment. Marking of a document as an exhibit. Other trial court refuse ಮಾಡಿದಾಗ prosecution ಸುಮ್ಮನೆ ಇತ್ತು, complainant who was examined as PW7 ಅವನು ಹೈಕೋರ್ಟಿಗೆ ಹೋದ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ was erred in refusing marking the said document. ಅವಾಗ maintainability ಬಂತು. When the prosecution has not objected to can an informant, the complainant can invoke revisional jurisdiction ಅಂತ. High court it cannot ಅಂತ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ he can ಅಂತ ಹೇಳಿದ್ರು. ಇಲ್ಲಿ ಬೇರೆ, ಇಲ್ಲಿ not on the said point. Final judgment had already pronounced by the trial court. You did not challenge that. State went in appeal. It lost the appeal. Because the state lost the appeal, you came here. State did not come. ಸೊ ಈ ಜಜ್ಮೆಂಟ್ ಅದು ಬೇರೆ ಬೇರೆದು ಇರ್ತದೆ. ಒಂದು ತಿಳಿರಿ, ಯಾವುದೇ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಂತ ಹೇಳಿಕೊಳ್ಳ ಹೈಕೋರ್ಟ್ ಹೆದರಲ್ಲ, ಜಾಸ್ತಿ ಕೇರ್ಫುಲ್ ಆಗಿ ನೋಡ್ತದೆ. ನೀವು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೀಗೆ ಹೇಳಿದೆ ಅಂತ ಹೇಳಿ ಜಜ್ಮೆಂಟ್ ಇಡ್ಬೇಕಾದ್ರೆ ಮೂರು ಸರ್ತಿ ಓದ್ಕೊಂಡು ಇಡ್ಬೇಕು. ಇದು ಬೇಸಿಕ್ ಡ್ಯೂಟಿ ಆಫ್ ಅನ್ ಅಡ್ವೊಕೇಟ್. ಮಾಡಿ ನೋಡ್ಕೊಂಡು ಬನ್ನಿ, ನಾಡಿದ್ದು ಹಾಕಿರ್ತೇನೆ. ಕೌನ್ಸಿಲ್ಸ್ ಫ್ರಮ್ ಬೋತ್ ಸೈಡ್ ಪ್ರೆಸೆಂಟ್. For the learned counsel for the petitioner open up his argument, and learned counsel for the respondent number 2 to 5 submitted that since the present petitioner who claims himself to be the complainant had not challenged the judgment of acquittal passed by the trial court, but it was only the state which had filed the appeal and lost the appeal, cannot challenge the judgment of acquittal. The learned counsel for the petitioner pray for a short accommodation. Commence his argument in the matter. This is the matter on 7/11. 8/11. That's great.
Number 42, Vijay Kumar Prakash, Sri Lakshmi Kantrao.
ಒಂದು ಸಂಶಯ Yes.
One particular question of law, my lord, your lordship directed me to search the point whether case can be closed even without the consent of the party. Lord, I could manage to get one judgment. Lord, because the instruments private limited and another process. Confusion I found.
Veritas and Instruments Private Limited
Yes.
versus Kanchan Mehta,
Yes.
2018, 1 ACC 560.
Please. The last paragraph, at paragraph 18, my lord.
Hmm.
The lordships have held.
Hmm.
In the paragraph, but at internal page 571.
18.3, though compounding requires consent of both parties, even in absence of such consent, the court, in the interest of justice, on being satisfied that the complainant has been duly compensated, can in its discretion close the proceedings and discharge their case.
Please, that is it.
ಅಲ್ವೇ?
Dictum.
ನಿಮ್ಮ ಹೋಮ್ವರ್ಕ್ ನಾನು ಮಾಡಿದ್ದೇನೆ. ಏನ್ ಹೇಳ್ತೀರಪ್ಪ? ಈಗ ಅವ್ರು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇಂದ ಒಂದು ತೀರ್ಪು ತಂದಿದ್ದಾರೆ. ತೀರ್ಪು ತಂದು ಶ್ರೀನಿವಾಸ ಮೂರ್ತಿ ಒಪ್ಪಿಗೆ, ಶ್ರೀನಿವಾಸ ಮೂರ್ತಿ ಏನ್ ಹೇಳ್ತಾರೆ ಅದು ಕೇಳೋದೇ ಬೇಡ. ನಾನು ಯಾವಾಗ ಪೂರ್ತಿ ಫೈನ್ ಅಮೌಂಟ್ ಕೊಡ್ಲಿಕ್ಕೆ ತಯಾರಿದ್ದೇನೆ, ಪೂರ್ತಿ ಫೈನ್ ಅಮೌಂಟ್ ಕೊಡ್ತೇನೆ ಅಂತ ಹೇಳ್ತೇನೆ, ಕೋರ್ಟ್ ರಾಜಿ ಮಾಡ್ಕೊಳ್ಬಹುದು, ಅವಾಗ ನಿಮ್ಮನ್ನ ಕೇಳುವ ಪ್ರಶ್ನೆ ಇಲ್ಲ. ನನಗ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆ ತೀರ್ಪಿನ ಪ್ರಕಾರ ರಾಜಿ ಮಾಡಿಸಿ ಕೊಡಿ ಅಂತ ಕೇಳ್ತಿದಾರು. ಲಾಸ್ಟ್ ಟೈಮ್ ಇದನ್ನೇ ನಿಮ್ಗೆ ಹೇಳಿತು. ನಮಗೆ ಬಿಟ್ಟಿರೋ ಪ್ರಶ್ನೆ ಇಲ್ಲ. ಅವಿಂದ ಅವು ಕೋರ್ಟಿನಲ್ಲಿ ಅದು ಬರೋಲ್ಲ. ಕೋರ್ಟಿನಲ್ಲಿ ನಿಮಗೆ ಬಿಟ್ಟಿದ್ದು ಅನ್ನೋ ಪ್ರಶ್ನೆ ಬರೋಲ್ಲ. ನಿಮ್ಗೆಲ್ಲಾ ಹೇಳಿದ್ರು ನೀವು ಕೇವಲ ಬುದ್ಧಿವಂತಿಕೆ. ನೀವು ವೈಶ್ರೇನ್ರಿ, ಶಟ್ರೇನ್ರಿ? ನಿಮ್ ಮಾತಿನಲ್ಲೇ ಗೊತ್ತಾಗ್ತದೆ. ಬುದ್ಧಿವಂತಿಕೆ ಉತ್ತರ ಕೊಡ್ತೀರ ಹೊರತು ನೀವು ಏನು ಮೈಂಡ್ ಅಪ್ಲೈ ಮಾಡ್ಬೇಕು ಮಾಡಲ್ಲ. ಮಾಡಿದ್ದೀರಿ ಗೊತ್ತಿದೆ, ಆದ್ರೆ ಬುದ್ಧಿವಂತಿಕೆ ಉತ್ತರ ಕೊಡ್ತೀರಿ. ಅದಿಬ್ರಿಗೆ ಮಾತ್ರ ಸಾಧ್ಯ, ಶೆಟ್ರಿಗೆ, ಮಾರ್ವಾಡಿಗಳಿಗೆ. ನಿಮ್ಗೆ ಅವತ್ತು ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳಿತ್ತು, ದುಡ್ಡು ಕೊಟ್ಟು 20 ವರ್ಷ ಆಗಿದೆ, ದುಡ್ಡಿಗೆ ನಾನ್ ಬಡ್ಡಿ ಕೊಡ್ತಿದ್ದೇನೆ, ಬೇರೆಯವರಿಂದ ಸಾಲ ತಂದೆ, ಅದರಿಂದ ನನಗೆ ಇಷ್ಟು ಲಾಸ್ ಆಯ್ತು. ಅವಾಗಾಗಿ ದುಡ್ಡಿಗೆ ಏನ್ ಬೆಲೆ ಇತ್ತು, ಈಗೇನ್ ಅದೇ 4 ಲಕ್ಷ ರೂಪಾಯಿಗೆ ಇವತ್ತೇನ್ ಬೆಲೆ ಇದೆ, ಅದೆಲ್ಲದೂ ಲೆಕ್ಕ ಹಾಕಿರಿ. ಇವ್ರು ನನಗೆ ಅಸಲಲ್ಲ, ಅಸಲಿನ ಡಬಲ್ ಕೊಟ್ರು ಕೂಡ ಅದು ಅವಾಗಿನ ದುಡ್ಡಿಗೆ ಸಮಾನನೇ ಅಲ್ಲ ಅಂತ ನೀವ್ ಏನ್ ಹೇಳ್ತೀರಿ ಅದನ್ನ ಇಲ್ಲ ಅಂತ ಕೋರ್ಟ್ ಹೇಳಲ್ಲ. ಆದ್ರೆ ಈ ಕ್ರಿಮಿನಲ್ ಕೇಸಿನಲ್ಲಿ ಅದನ್ನೆಲ್ಲ ಕೊಡ್ತಕ್ಕಂಥದ್ದು, ಈ ಬಡ್ಡಿ, ಡ್ಯಾಮೇಜು, ನಿಮ್ಗಾಗಿರೋ ಲಾಸು, ನಿಮ್ಗಾಗಿರ್ತಕ್ಕಂಥ ಕಷ್ಟ ನಷ್ಟಗಳು, ಅದ್ಯಾವುದನ್ನು ಕ್ರಿಮಿನಲ್ ಕೇಸಿನಲ್ಲಿ ಪರಿಗಣಿಸಲಿಕ್ಕೆ ಬರಲ್ಲ ಅಂತ ನಿಮ್ಗೆ ಹೋದ್ಸರ್ತಿನೇ ಹೇಳಿತ್ತು ಕ್ಲಿಯರ್ ಆಗಿ. ಅಷ್ಟೆಲ್ಲ ಹೇಳಿ ಆದ್ರ ಮೇಲೆ ನಿಮ್ಮ ವಕೀಲರಿಗೆ ಹೇಳಿದಾಗ, ನಿಮ್ಮ ವಕೀಲರನ್ನ ಕೇಳಿದಾಗ ನೀವು ಕೈ ಎತ್ತಿದ್ರಿ. ನಿಮ್ಮ ವಕೀಲರು ಹೇಳಿದ್ರು, ಸ್ವಾಮಿ ನಮಗೆ ನ್ಯಾಯ ಕೊಡಿಸ್ರಿ. ಅದಾದ್ರ ಮೇಲೆ ಕೋರ್ಟ್ ಹೇಳಿತು, ನೋಡಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇಂದ ಒಂದು ಜಜ್ಮೆಂಟ್ ಇದೆ, ನೀವು ರಾಜಿ ಮಾಡ್ಕೊಳ್ತೀರಿ ಅಂತಾದ್ರೆ ಎದುರುಗಡೆ ಒಪ್ಪದೆ ಹೋದ್ರೆ ಅವ್ರನ್ನ ಒತ್ತಾಯ ಮಾಡ್ಬೇಕಂತೇನಿಲ್ಲ, ಅಂತದೊಂದು ಜಜ್ಮೆಂಟ್ ಇದೆ, ನೋಡ್ಕೊಂಡು ಬನ್ನಿ ಅಂತ ಹೇಳಿದ್ದೇನೆ. ಇವತ್ತು ಅವ್ರು ಜಜ್ಮೆಂಟ್ ತಗೊಂಡ್ಬಂದಿದ್ದಾರೆ. ಈಗ ನೀವು ರಾಜಿಗೆ ಒಪ್ಪಿದ್ರೆ ಉಂಟು, ನಿಮ್ಗೆ ಅಟ್ಲೀಸ್ಟ್ ಅವರು 1 ಲಕ್ಷ ರೂಪಾಯಿ ಏನು ಕೊಡ್ತೀನಿ ನಿಂತಿದ್ದಾರೆ ಅದು ನಿಮಗೆ ಬರ್ತದೆ. ಅದಿಲ್ಲದೆ ಹೊರ ಅದು 1 ಲಕ್ಷ ರೂಪಾಯಿ ಅವ್ರು ಸರ್ಕಾರಕ್ಕೆ ಕಟ್ತಾರೆ, ಆ ತೀರ್ಪನ್ನು ಇಲ್ಲಿ ಕೊಡ್ತಾರೆ. ಆ ತೀರ್ಪನ್ನು ಒಪ್ಪಗೊಳ್ಳಬಹುದಾದ್ರೆ ಒಪ್ಪಗೊಳ್ತೇವೆ, ಒಪ್ಪಗೊಂಡ ಪಕ್ಷದಲ್ಲಿ ಅವ್ರು ಬಿಡುಗಡೆ ಆಗ್ತಾರೆ, ಒಪ್ಪಗೊಳ್ಳದೆ ಹೋದ್ರೆ ಇಲ್ಲ. ಹಾಗಾಗಿನೇ ನಿಮ್ಮ ವಕೀಲರು ಈ ವಿಷಯ ಗೊತ್ತಿರೋದ್ರಿಂದಲೇ ಈ ತಾರೀಕಿಗೆ ನಾನು ಬರಲ್ಲಪ್ಪ, ಬೇರೆ ವಕೀಲರು ನೋಡ್ಕೊ ಹೋಗು ಅಂದ್ರು. ಅವರಿಗೂ ಸಾಕಾಗಿ ಹೋಯ್ತು. ನೀವು ನೇರ ಪ್ರಶ್ನೆ ಕೊಡೋದ್ರ ಬದಲು ನಮ್ಗೆ ಕೊಡಿಸಿರೋ ದುಡ್ಡು 20 ವರ್ಷ ಆಗಿದೆ ಕೊಟ್ಟು, ನೀವು ವಕೀಲರ ಹತ್ರ ಅದನ್ನೇ ಹೇಳಿದ್ರಿ. ಈಗ ನಿಮಗೆ ಕೊಡೋದಲ್ಲದೆ ಅವ್ರು ಅದ್ರ ಮೇಲೆ 60,000 ರೂಪಾಯಿ ಕೋರ್ಟಿಗೆ ಕಟ್ಟಬೇಕಾಗ್ತದೆ, ದಂಡ ಶುಲ್ಕ ಅಂತ, ಗ್ರೇಡಿಂಗ್ ಕಾಸ್ಟ್. ಯು ಆರ್ ಲೈಬಲ್ ಟು ಪೇ. ನೋ ಎಕ್ಸ್ಕ್ಯೂಸ್.
No, I am not seeking. Graded cost. Taking to 1,70,000. which I paid in the trial, that shows my bona fides.
Hmm.
To settle the matter, not to protract proceedings, take advantage of the delay that is caused in any proceedings.
Sir, payment of the partial amount was a requirement of law or as per the judicial dictum.
No,
That would not come in, say, readjusting the grading cost or showing any remission for the graded cost.
requirement of law, nor was it a requirement of direction by the court. This 1,70,000 was paid by me towards settlement, which he received during pendency of the appeal. This 1 lakh, Lord, the lordship, like I submitted on the last hearing day, there were three accused. One, of course, is the company, my lord. We will not address that. Accused number 1, that is me. Accused number 2, another director.
Whether that was permissible, that was your internal arrangement. Director number 2, accused number 2 shall go out and you confine yourself, say, out of 4 lakhs rupees, your liability would be 2 lakh rupee. Another director's liability would be 2 lakh rupee was your internal understanding.
I demonstrated my bona fides by making that payment. And in this
Sir,
judgment,
that your internal arrangement or adjustment or understanding would not say bind the law in showing you any lenience or in mitigating the quantum of the graded cost. ಅಷ್ಟೇ ಅದು ಮಾಡಿ ಮುಂಚೆನೆ ಮಾಡಬೇಕಿತ್ತು ಅವ್ರು ಈಗ ಈ ಹಂತದಲ್ಲಿ ಬರೋದ್ರಿಂದ ಅದು
I have deposited 1,30,000. Those original receipts I will be forwarded. Both are before the trial. 1 lakh.
Letter counsel for the petitioner files a memo. You are filing a memo? Memo. Along with a receipt and submits that. Along with 2 receipts and submits that. Those 2 receipts. Evidences the payment of rupees 30,000 plus rupees 1 lakh. That is in total rupees 1,30,000 by him in the trial court. Para 3 in the memo. What made you to mention para 3 in the memo?
Para 3 was my lord. Say, amount is 4 lakhs, my lord.
So is there any direction to you to pay the remaining sum of rupees 1 lakh?
No.
No, in the absence of any direction by the court.
It is only paid.
Why are you, say, making a mention that you seek 2 weeks time to deposit the balance amount when there is no order for depositing of the balance amount?
That's only by prayer.
You cannot may have that prayer, the memo.
Your lordship,
Kodiyadari. Aa para tegiri.
that portion shall I?
Only that portion.
Yes.
Para tegiri. With your full signature.
Great. I do.
The learned counsel for the respondent not present. Learned counsel for the petitioner reiterates his submission made on 19/10/2022 and submits that he makes an application under section 147 NI Act seeking permission to compound the matter by himself, even though the complaint is not agreeable. for the terms of compromise. Shri Sriram Murthy Yam, son of Prahlad Rao, who was present on 19/10/2022, is also present in the court and prays for a day's accommodation to make a submission or to proceed further in the matter. This is the matter on 8/11.
7 also.
7th matters are a bit heavy. 9th I can give you. 9, 11.
This would be direct the respondent counsel to be present because he cannot at this stage recuse. It's not, it is.
On
not-
which day? The respondent counsel to be present and proceed further in the matter by duly obtaining the instruction from his client. In case of non-appearance of learned counsel for the respondent, the court may proceed to pass appropriate order in the matter. ಅವತ್ತಿನ ದಿವಸ ವಕೀಲರನ್ನು ತಯಾರು ಮಾಡಿ ಕರ್ಕೊಂಡ್ ಬನ್ನಿ, ಇಲ್ಲೇ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ, ಕೋರ್ಟ್ ಮುಂದುವರಿಬೇಕಾಗ್ತದೆ ಆದೇಶದಲ್ಲಿ. ಅವ ನೀವು ಬರುವ 1 ಲಕ್ಷ ರೂಪಾಯಿನೂ ಬರದೇ ಇರುವ ಸಾಧ್ಯತೆ ಇದೆ. ಕಾಸ್ಟ್ ಬಗ್ಗೆ ಪೂರ್ತಿ ಹೇಳಿ. His liability. Yes, next ಯಾವ್ದಿದೆ?
Serial number 44, DC Jagdish, Umar Farooq,
One for the petitioner. Alone present. ಯಾವಾಗ ಮಾಡ್ತೀರಿ? Since the court time is over, is this matter on 9/11? Yes.
serial number 45, Vishwanath Pujari, NCGP,
The counsel from both sides present. Since the court time is over, the matter should not be taken up today. List this matter on 8/11/2022.
serial number 47, Veerabhadra Swami H, HP, NR Girisha, Yes.
There is application for 147.
Hmm.
Present before this court. Okay.
Application.
Yes.
Section 147 of.
Hmm.
21/4/2022, my lord. Both the parties are present before this court and compromise matters. But my lord was, fine amount is not paid. My lord is recalled.
ವಕೀಲರುಗಳು ಯಾವತ್ತೂ ಕಕ್ಷಿದಾರರಿಗೆ ತಿಳುವಳಿಕೆ ಕೊಡೋದ್ರಲ್ಲಿ ಇರಬೇಕೇ ಹೊತ್ತು ಕಕ್ಷಿದಾರನ ಹಾದಿ ತಪ್ಪಿಸೋದ್ರಲ್ಲಿ ಅಥವಾ ಅವ್ರನ್ನ ಮಿಸ್ಲೀಡ್ ಮಾಡೋದ್ರಲ್ಲಿ ಇರಬಾರ್ದು. ದುರಂತ ಅಂದ್ರೆ ಈ ಕೇಸಿನಲ್ಲಿ ನಿಮ್ಮಿಬ್ಬರನ್ನು ನಾನು ನೋಡ್ತಾ ಇದ್ದೇನೆ. 4-5 ಹಿಯರಿಂಗ್ ಇಂದ ನಾನು ಬಹಳ ಕಠೋರವಾಗಿ ಹೇಳ್ತಾ ಇದ್ದೇನೆ. ಐ ಆಮ್ ಕನ್ಸ್ಟ್ರೈನ್ ಟು ಒಂದು ಫಾಲ್ಸ್ ಅಶ್ಯೂರೆನ್ಸ್ ಕೊಡ್ತಾ ಇದ್ದೀರಿ ಅಥವಾ ಸರಿಯಾದ ಅಡ್ವೈಸ್ ಅವರಿಗೆ ಮಾಡ್ತಾ ಇಲ್ಲ. ಏನೇನೆಲ್ಲ ಡ್ರಾಮಾಗಳು ಮಾಡ್ಬೋದು ಎಲ್ಲ ಡ್ರಾಮಾಗಳು ನನ್ನ ಕೋರ್ಟಿನಲ್ಲಿ ನಡೀತಾ ಇದೆ. ಈ ಮ್ಯಾಟರ್ ನಲ್ಲಿ
ಯಾವುದು ಅಂತ ನಾವು ಮಾಡಿ
ಆಗಿದೆ, ಆಗ್ತಾ ಇದೆ. ಇಲ್ಲಿಯೂ ಇದೆ ದಾಖಲೆ. ಈಗ ಹಾಕಿರ್ತಕ್ಕಂಥ ಕಾಂಪ್ಲೇನ್ಸ್ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿಯೂ ಇದೆ. ಆತ ಒಳಗೆ ಹೋಗ್ಲಿ, ಆತ ಕೆಲಸ ಕಳ್ಕೊಳ್ಳಿ, ಗೊತ್ತಾಗ್ತದೆ ಆತನಿಗೆ ಅಷ್ಟೇ, ಬೇರೆ ದಾರಿ ಇಲ್ಲ. ಆತ ಒಳಗೆ ಹೋಗ್ಲಿ, ಕೆಲಸ ಕಳ್ಕೊಳ್ಳಿ. ಗ್ರೇಡೆಡ್ ಕಾಸ್ಟ್ ಬಗ್ಗೆ ಎಲ್ಲಿಯಾದ್ರೂ ವಿಶ್ವರ್ ಮಾಡಿದ್ದೀರಾ? ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಾಗ ಎಂಟೈರ್ ಫೈನ್ ಅಮೌಂಟ್ ಅಂತ ಹೇಳಿದಾಗ ನೀವು ಬರೀ 3,000 ರೂಪಾಯಿ ಕಟ್ಟಿದ್ರು. ಅವ್ರು ಉಳಿದ ಮಧ್ಯ ಮಾತಾಡಿದ್ರೆ ನಾನು ಮಾತಾಡಲ್ಲ. 3,000 ರೂಪಾಯಿ ಕಟ್ಟಿದ್ರು ಪೂರ್ತಿ ಅಲ್ಲ, ಅವರು ರಾಜಿ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅಂದ್ರಿ. ಕೋರ್ಟ್ ಏನ್ ಹೇಳಿತ್ತು ನಿಮಗೆ? ಫೈನ್ ಅಮೌಂಟ್ ಇರೋದು ನಿಮಗೆ 3,03,000. ಬೇಲ್ ವಾಸ್ ಗ್ರಾಂಟೆಡ್ ಟು ಹಿಮ್ ಆಫ್ಟರ್ ಹಿ ವಾಸ್ ಬ್ರಾಟ್ ಬೈ ದ ಪೊಲೀಸ್ ಬೈ ಎಕ್ಸಿಕ್ಯೂಟಿಂಗ್ ನಾನ್ ಬೇಲಬಲ್ ವಾರೆಂಟ್ with a condition that he shall deposit the entire fine amount. ಎಂಟೈರ್ ಫೈನ್ ಅಮೌಂಟ್ ಅಂದ್ರೆ 3,03,000 ರೂಪಾಯಿ ಕೋರ್ಟ್ನಲ್ಲಿ ಕಟ್ಟಬೇಕು. ಬರೀ 3,000 ಅಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. ಆದ್ರೂ ಇನ್ನೂ ಒಂದು ಟೈಮ್ ಕೊಡ್ತು ಕೋರ್ಟು. 1 ವಾರ ಟೈಮ್ ಕೊಟ್ಟು 1 ವಾರದೊಳಗೆ ಪೂರ್ತಿ ಅಮೌಂಟ್ ಫೈನ್ ಅಮೌಂಟ್ ಎಂಟೈರ್ ಫೈನ್ ಅಮೌಂಟ್ ಕಟ್ಟಬೇಕು ಅಂತ ಹೇಳಿ 28/10 ಆರ್ಡರ್ ಮಾಡಿದ್ರು. ಎಂಟೈರ್ ಫೈನ್ ಅಮೌಂಟ್ ಕಟ್ಟಿದ್ರ ಮೇಲೆ ಮಾತ್ರವೇ ಇದು ರಾಜಿ ಅನ್ನೋದನ್ನ ತಗೊಳ್ತೇನೆ ಅಂತ. ಗ್ರೇಡೆಡ್ ಕಾಸ್ಟ್ ಅವತ್ತಿನ ದಿವಸನೇ ನಿಮಗೆ ಹೇಳಿತ್ತು. 21ನೇ ತಾರೀಕು ಹೇಳಿತ್ತು, 28ನೇ ತಾರೀಕು ಹೇಳಿತ್ತು ಗ್ರೇಡೆಡ್ ಕಾಸ್ಟ್ ಕಟ್ಟಬೇಕು. ಅವ್ರದ್ದೇ ನೆಗೋಸಿಯೇಷನ್ ಇದೆ, ಅದರಲ್ಲಿ ಗ್ರೇಡೆಡ್ ಕಾಸ್ಟ್ ಇಂದ ಒಂದು ಪಾಯಿಂಟ್ ಸೇರಿಸ್ರಿ. ಬಿಕಾಸ್ ಅಕ್ಯೂಸ್ ಶಲ್ ಬಿ ಲೈಬಲ್ ಟು ಪೇ 45,000 rupees as ಗ್ರೇಡೆಡ್ ಕಾಸ್ಟ್ ಅನ್ನೋದನ್ನು ನಿಮಗೆ ಹೇಳಿದ್ವಿ. ಇವತ್ತಿನ ದಿವಸ ಹೈ ಡ್ರಾಮಾ ಮಾಡ್ಕೊಂಡು ಬಂದಿದ್ದೀರಿ. ಒಂದು ಜಾಯಿಂಟ್ ಅಪ್ಲಿಕೇಶನ್, ಒಂದು ಜಾಯಿಂಟ್ ಮೆಮೊ. ಅದರಲ್ಲಿ ಕೋರ್ಟು ಎಂಟೈರ್ ಫೈನ್ ಅಮೌಂಟ್ before the next date of hearing, the balance amount what he has not paid shall be paid ಅಂತ ಹೇಳಿ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದೆ. reiterating the observation made on the previous dates of hearing ಅಂತ. ಅದ್ರ ಬಗ್ಗೆ ಸೊಲ್ಲೆತ್ತಿಲ್ಲ. ನೋ ವಿಸ್ಪರ್ ಇನ್ ದಟ್ ರಿಗಾರ್ಡ್. ಏನು ಹೇಳಲಿಲ್ಲ. ಕಾಂಪ್ಲೇಂಟ್ಸ್ ಅಫಿಡವಿಟ್ ತಂದಿದ್ದೀರಿ, ಎಂಟೈರ್ ಫೈನ್ ಅಮೌಂಟ್ 3,000 ರೂಪಾಯಿ ನಾನು ಕೊಟ್ಟಿದ್ದೇನೆ ಅಂತ. 3,000 ರೂಪಾಯಿ ಎಂಟೈರ್ ಫೈನ್ ಅಮೌಂಟ್ ಅಲ್ಲ, 3,03,000 ಅಂತ ನಿಮ್ಗೆ ಹೇಳಿದ್ರೆ, ಈ ಜಾಯಿಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಅದ್ರ ಬಗ್ಗೆ ಏನು ಸುದ್ದಿ ಇಲ್ಲ, ವಿಷಯ ಇಲ್ಲ, ಸೊಲ್ಲತ್ತಿಲ್ಲ. ನಾಟ್ ಇವನ್ ಎ ಸಿಂಗಲ್ ವರ್ಡ್. ಎಂಟೈರ್ ಫೈನ್ ಅಮೌಂಟ್ ವೆನ್ ಹಿ ವಾಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಬಿ ಡೆಪಾಸಿಟೆಡ್ ಆನ್ 28/10 ಅದ್ರ ಬಗ್ಗೆ ಏನೂ ಇಲ್ಲ. ಎರಡನೇದಾಗಿ ಗ್ರೇಡೆಡ್ ಕಾಸ್ಟ್ ಬಗ್ಗೆ ಏನು ಸುದ್ದಿ ಇಲ್ಲ, ಸುಳಿವಿಲ್ಲ. ಅಕ್ವಿಟ್ ಮಾಡ್ರಿ ಅಂತ ಅಷ್ಟೇ ಕೇಳಿದ್ದೀನಿ.
ಗ್ರೇಡೆಡ್ ಕಾಸ್ಟ್ ಯಾರು ಕಟ್ಟಬೇಕು ಅಂತ ನಾವು ಸೆವೆರಲ್ ಟೈಮ್ ಆಫೀಸಲ್ಲಿ ಕೋರ್ಟ್ ಡೈರೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ನಾವು ಇಂಥವ್ರು ಕಟ್ಟಿ ಅಂತ ನಾವು ಹೇಳಕ್ ಬರಲ್ಲ ಸರ್. ಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ ಮಾಡಿದ್ಮೇಲೆ ನೀವು ಪೇಡ್ ದಿ ಕಾಸ್ಟ್ ಅಂತ ಹೇಳಿದ್ರು. ರೆಡಿ ಟು ಪೇ ದಿ ಗ್ರೇಡೆಡ್ ಕಾಸ್ಟ್ ಆಲ್ಸೋ. ನಾವು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟರೆ ವಿದಿನ್ ಟೈಮ್ ನಾವು ಕಟ್ಟಕ್ಕೆ ರೆಡಿ ಇದ್ವಿ. ನಾವು ಬೆಳಿಗ್ಗೆ ಯಾರು ಹಿಡಿ ತಗೋಬೇಕು ಅಂತ ಗೊತ್ತಿದ್ದೇನೆ, ನಾವು ಹಂಗೇನೆ ಸಾರಿ. ಅದು ನಾವು ಆಫೀಸಲ್ಲಿ
ನಾನು ಪ್ರತಿ ಸರ್ತಿಯೂ ಇಂಥ ವಿಷಯದಲ್ಲಿ ಓಪನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೇಳಬಾರ್ದು ಅಂತೀನಿ. ನೀವು ವಕೀಲರು ನನ್ನನ್ನು ಹೇಳೋದಕ್ಕೆ ಉದ್ರೇಕಿಸ್ತೀರಿ, ಹೇಳಿಸ್ತೀರಿ. ಗ್ರೇಡೆಡ್ ಕಾಸ್ಟ್ ಯಾರಿಗೆ ಕಟ್ಟಬೇಕು, ಏನ್ ಕಟ್ಟಬೇಕು ಅಂತ ಕೋರ್ಟಿನ ಕ್ಲರ್ಕ್ ಹೇಳೋದಲ್ರಿ, ಕೋರ್ಟಿನ ಸೆಕ್ಷನ್ ಆಫೀಸರ್ ಹೇಳೋದಲ್ರಿ, ಕೋರ್ಟಿನ AR DR ರಿಜಿಸ್ಟ್ರಾರ್ ಜನರಲ್ ಹೇಳೋದಲ್ರಿ, ನಾನು ಹೇಳೋದಲ್ರಿ. ಗ್ರೇಡೆಡ್ ಕಾಸ್ಟ್ ಕಟ್ಟಬೇಕು ಅಂತ ಏನ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ಇದೆ ಅವರೇ ಹೇಳಿದ್ದಾರೆ ಯಾರಿಗೆ ಕಟ್ಟಬೇಕು, ಹೆಂಗೆ ಕಟ್ಟಬೇಕು ಅಂತ. ನಾನು ಹೇಳೋದೇನು, ಅವ್ರು ಹೇಳೋದೇನು, ಯಾರು ಹೇಳೋದಲ್ಲ. ನೀವು ವಕೀಲರುಗಳು ಓದಲ್ಲ. ನೀವು ಯಾರನ್ನೋ ಹೋಗ್ತೀರಿ, ಯಾರೋ ಒಬ್ಬ ಕ್ಲರ್ಕ್ ಕೇಳ್ತೀರಿ, ಇನ್ಯಾರೋ ಒಬ್ರು ಕೇಳ್ತೀರಿ, ಅವ್ನು ಹೇಳಿದ್ದೆ ಕಾನೂನು ಅಥವಾ ಅವ್ನು ಹೇಳಿದ್ದೆ ಲಾ ಅಂತ ಮಾಡ್ತೀರಿ. ನೀವು ಓದಿ ಕಂಡ್ಬಿಟ್ಟು ಅವ್ರನ್ನೇ ಹೋಗಿ ಕೇಳ್ತೀರಿ. ನೀವು ಯು ಆರ್ ದಿ ಕೋರ್ಟ್ ಆಫೀಸರ್, ಈಸ್ ಅನ್ ಆರ್ಡಿನರಿ ಕ್ಲರ್ಕ್. ಗ್ರೇಡೆಡ್ ಕಾಸ್ಟ್ ಯಾರಿಗೆ ಕಟ್ಟಬೇಕು,
ಸೆಷನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆದ್ರೆ ಯಾರಿಗೆ ಕಟ್ಟಬೇಕು, ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಆದ್ರೆ ಯಾರಿಗೆ ಕಟ್ಟಬೇಕು, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆದ್ರೆ ಯಾರಿಗೆ ಕಟ್ಟಬೇಕು ಅಂತ ಹೇಳಿ ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳಿದ್ದಾರೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ನಲ್ಲಿ. ನೀವು ಓದಲ್ಲ, ದೊಡ್ಡ ದುರಂತ ಅದು. ಯಾವ್ದೆಲ್ಲ ಲಾಯರ್ಗಳು ಓದ್ಬೇಕು, ಅವ್ರು ಓದೋದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಯಾರೋ ಒಬ್ರು ನಾಲೆಡ್ಜ್ ಏನೋ ಇದು ಹಿಂಗ್ ಬಂದಿದೆ ಏನ್ ಮಾಡ್ಬೇಕಪ್ಪ, ಹಿಂಗ್ ಬಂದಿದೆ ಏನ್ ಮಾಡ್ಬೇಕು, ಯಾರೋ ಒಬ್ರು ಕಲಿಂಗ್ನ ಕೇಳಿದೋ ಅಥವಾ ಏನೋ ಕ್ಲರ್ಕ್ನ ಕೇಳಿದೋ ಮಾಡ್ತಿರೋ ಹೊರತು ಪುಸ್ತಕ ಇದ್ರು ಕೂಡ ನೋಡಲ್ಲ, ಓದಲ್ಲ, ಏನ್ ಮಾಡ್ಬೇಕು? ಅಲ್ಲೇ ಕಟ್ಟೋದಲ್ಲ, ಡಿಮಾಂಡ್ ಆಫ್ ತಗೊಂಡ್ ಬರೋದು, ತಗೊಂಡ್ ಬನ್ನಿ ನೋಡಿ ಆ ಕೇಸ್ನಲ್ಲಿ ಯಾರಿಗೆ ಕಟ್ಟಬೇಕಂತಿದೆ, ಯಾರ ಹೆಸರಿಗೆ ತಗೊಳ್ಬೇಕಂತಿದೆ, ತಗೊಂಡ್ ಬನ್ನಿ ಮಾಡುವ. ಇಲ್ಲ ಹೋದ್ರೆ ನಾನ್ ಅವೈಲಬಲ್ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಮಾಡುವ. ಇದು ಬರಲ್ಲ ಕಾಂಪ್ಲೇಂಟ್ಸ್ ಮೆಮೊ. ಫೈನ್ ಇರೋದು 3,03,000 ರೂಪಾಯಿ. ಹೌದು ರೀ, ನಾನು ಅದನ್ನು ಬರ್ಕೊಳ್ಬೇಕಾದ್ರೆ ಗ್ರೇಡೆಡ್ ಕಾಸ್ಟ್ ಕಟ್ಟಿ ಬಂದು ಹೇಳ್ಬೇಕಿಲ್ಲಿ. ಈಗಿನ ಫ್ಯಾಕ್ಟ್ ನಾನು ಅದಕ್ಕೆ ಲೀನಿಯನ್ಸ್ ಹೋದ್ ಸರ್ತಿಂದಲೂ ನಾನು ಕಾಯ್ತಾ ಇರೋದು ಅದಕ್ಕೆ. 3,03,000 ರೂಪೀಸ್ ಎಂಟೈರ್ ಅಮೌಂಟ್ ಕಟ್ಟಬೇಕು, ಇಮಿಡಿಯೇಟ್ ಕಟ್ಟಬೇಕು ಅಂತ ಆರ್ಡರ್ ಮಾಡಿಯೂ ಕೂಡ ಇನ್ನೂ ನಾನು ಅದನ್ನ ಇನ್ಸಿಸ್ಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ಇಲ್ಲೇ ಹೋದ್ರೆ ಕಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿ ನಾನು NBW ರೀಆರ್ಡರ್ ಮಾಡ್ತಿದ್ದೆ. ಆದ್ರೂ ಅವ್ರು 3 ಲಕ್ಷ ನಿಮ್ ಕೈಗೆ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತ ನೀವು ಒಪ್ಪಗೊಳ್ತಾ ಇರೋದ್ರಿಂದ ನಾನು ಅವರಿಗೆ ಮತ್ತೆ NBW ಇಶ್ಯೂ ಮಾಡ್ತಾ ಇಲ್ಲ. ಗ್ರೇಡೆಡ್ ಕಾಸ್ಟ್ ಕಟ್ರಪ್ಪ, ಕ್ಲೋಸ್ ಮಾಡೋಣಂತೆ, ಬಿಡುಗಡೆ ಆಗ್ತೀರಿ, ಹೋಗಿ ಉದ್ಯೋಗದಲ್ಲಿದ್ದೀರಿ, ಸರ್ಕಾರಿ ನೌಕರಿಯಲ್ಲಿ ಮುಂದುವರಿಸ್ಕೊಂಡು ಹೋಗ್ರಿ ಅಂತ ಲೀನಿಯನ್ಸಿ ತೋರಿಸ್ತಾ ಇದ್ದೇನೆ. ನೀವಿಬ್ರು ಪ್ರಾಪರ್ ಅಡ್ವೈಸ್ ಮಾಡ್ತಾ ಇಲ್ಲ ನಿಮ್ಮ ಕ್ಲೈಂಟ್ಗಳಿಗೆ. ಒಂದೋ ನಿಮ್ಮ ಕ್ಲರ್ಕ್ ಹೇಳಬೇಕು ಅಥವಾ ನಾನು ಹೇಳಬೇಕು. ವೈ ಶುಡ್ ವಿ ಟೆಲ್? ರೀಡ್ ಯುವರ್ ಸೆಲ್ಫ್. ಹೇಳಿ 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 ಎಲ್ಲ ಸಾಕಾಗಿದೆ ನನಗೆ. ಪ್ರತಿ ದಿವಸ 3-4 ಕೇಸಿನಲ್ಲಿ ನಾನು ಅದನ್ನೇ ಹೇಳಬೇಕಾಗ್ತದೆ. ಲಾಸ್ಟ್ ಟೈಮ್ ನಿಮಗೆ ಇರ್ಬೇಕು, ಇವರಿಗೆ ಏನ್ರಿ ತಮಾಷೆ ಮಾಡಿದ್ ನಾನು ಹೇಳ್ಬೇಕಂದ್ರೆ 10,000 ರೂಪಾಯಿ ಲೀಗಲ್ ಸರ್ವಿಸಸ್ ಕಮಿಟಿಗೆ ಕಟ್ಟಬೇಕಾಗ್ತದೆ ಫೀಸು. ನಮ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಹೇಳ್ಬೇಕಾದ್ರೆ ನಾನು ಎದ್ದೋದ್ರ ಮೇಲೆ ಬಹುಶಃ 500 ರೂಪಾಯಿ ನೀವು ಫೀಸ್ ಕಟ್ಟಬೇಕಾಗತ್ತೆ. ನೀವೇ ಓದ್ಕೊಂಡು ಕಟ್ಟದಾದ್ರೆ ನಿಮಗೆ ಅದು 2 ದುಡ್ಡು ಉಳಿಯುತ್ತೆ ಅಂತ ತಮಾಷೆನೂ ಮಾಡಿ ಹೋದೆ ನಾನು. ಯಾವ ಕೇಸ್ ಅಂತೂ ಹೇಳಿದೆ, ಸೈಟೇಷನ್ನು ಹೇಳಿದೆ. ಏನು ನೀವೆಲ್ಲ ಅಷ್ಟು ಕೂಲ್ ಆಗಿರ್ತೀರಿ ಅಂದ್ರೆ ನಾನೇನ್ ಮಾಡೋದು? There are counsels from both sides present. Parties are identified by them are also physically present. Both of them file a joint application under Section 147 NI Act. However, the said application is without an affidavit by the parties. The learned counsel from both sides prays for a day's accommodation to file either separate supporting affidavit or joint affidavit of the parties in support of the application filed today, and also come up with a demanded draft towards the grading cost of rupees 45,000 in favor of the member secretary of Karnataka State Legal Services Authority. ಗೊತ್ತಾಯ್ತೆ? 10,000 ರೂಪಾಯಿ ಉಳಿಸಿದ್ರಿ Legal Services Authority. Yes. List the matter on the top of the list on 4/11. ನಾಡಿದ್ದು ಬರ್ತದೆ, ತಗೊಂಡು ಬನ್ನಿ, ಬೆಳಗ್ಗೆನೆ ಬರ್ತದೆ, ಮ್ಯಾಟರ್ ರೀಚ್ ಆಗ್ತದೆ. ಆ ಡಿಮಾಂಡ್ ಡ್ರಾಫ್ಟ್ ಇಲ್ಲಿಯೇ ಕೊಡಿ, ರಿಜಿಸ್ಟ್ರಿಯಲ್ಲಿ ಕೊಡೋದಲ್ಲ. ಇಬ್ಬರಿಂದ ಒಂದು ಜಾಯಿಂಟ್ ಅಫಿಡವಿಟ್ ಮಾಡಿದ್ರಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ರೆ ಅಷ್ಟೇ ಹೇಳಿ. ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದೇವೆ, 3 ಲಕ್ಷ ನಮಗೆ ಆಲ್ರೆಡಿ ಬಂದಿದೆ, ಹಾಗಾಗಿ ಅವ್ರನ್ನ ಬಿಡುಗಡೆ ಮಾಡ್ಲಿಕ್ಕೆ ಏನು ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ ಅನ್ನೋದನ್ನ ಇದ್ರಲ್ಲಿ ಏನು ಹೇಳಿದ್ರೆ ಅಷ್ಟನ್ನೇ ಸಮ್ಮರಿ ಆಗಿ ಒಂದೇ ಪ್ಯಾರಾದಲ್ಲಿ ಹೇಳಿ ಮುಗಿಸ್ಕೊಂಡು ಹೋಗ್ತಾ ಇದೆ. ಅದಿಲ್ಲದೆ ಹೋದ್ರೆ ಅವರಿಗೆ ಸೋಮವಾರ ಬೆಳಗ್ಗೆ ಅವ್ರು ಡ್ಯೂಟಿಗೆ ಹೋಗಲ್ಲ, ಪರಪ್ಪನ ಅಗ್ರಹಾರಕ್ಕೆ ಅವ್ರ ಮನೆಯವ್ರು ಹೋಗ್ಬೇಕು ಕಾಫಿ ತಗೊಂಡು. ಮಾಡ್ಕೊಂಡು ಬನ್ನಿ. ಎಸ್, ಫೋರ್ತ್ ಈಗ ಇದು ಅಡ್ಮಿಷನ್ ಅಲ್ಲ, ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಎಲ್ಲ ಬರ್ತಾ ಇದೆ. ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಇಲ್ಲ, ಒಂದು ಫಸ್ಟ್ ಹಾಫ್ ಆಫ್ ದ ಲಿಸ್ಟ್, ಟಾಪ್ ಮೋಸ್ಟ್.
ಒಂದು ಫಸ್ಟ್ ಟಾಪ್ ಮೋಸ್ಟ್ ಮಾಡಿ
ಅದನ್ನ ಸೆಕೆಂಡ್
ಮಾಡಿ
ಕೈಯಲ್ಲಿ ನಾನು ಇನಿಷಿಯಲ್ ಮಾಡ್ತೇನೆ.
ನಾಡಿದ್ದು ಬನ್ನಿ ಕ್ಲೋಸ್ ಮಾಡ್ಕೊಂಡು ಹೋಗಿ ಮ್ಯಾಟರ್. ಎಸ್
Serial number 48, TV Vijay Raghavan, Gita Menon.
I appear for the respondent, my lord.
What question is involved in the matter of law?
Huh.
Under 48, 48, clearly said to not, cannot be initiated and
Next week I will hear you then.
not a summary proceedings, summons proceedings, and therefore covered by the judgment. You are not supposed to take the judgment. My learned friend, my respondent friend.
There are counsel from both sides present since the court time is over. Just the matter wrong. 10, 11. ತಾವು ಮನೆ ಜಜ್ಮೆಂಟ್ ಹಾಕಿ ಈ ಜಜ್ಮೆಂಟ್ ಬೇಕಾದ್ರೆ ಅಡ್ವಾನ್ಸ್ ಕಾಪಿ ಕೊಟ್ಟಿದೆಯಲ್ಲಿ ಯಾವ್ದಂತ ವಿಲ್ ಸಿ ದಟ್ ಮಾಡು.
Much obliged. Much obliged.
Other hearing will not, for that matter. It's the further hearing.
Huh.
Further hearing will not be matter.
On the top of the list and for ಬೇಗ ಬರ್ತದೆ so that you need not wait whole day.
Please.
Much obliged.
ಯಾವ ಜಜ್ಮೆಂಟ್ ಇಸ್ಕೊಂಡಿದೆ ಸರ್?
Serial number 49, SPP for petitioner, Nagaraj Jagde for respondent.
ಯಾರಿದ್ದೀರಿ ಇದರಲ್ಲಿ? Respondent. There are counsel from both sides present. Confirmation of acquittal is challenged by stater. There are counsels from both sides present since the court time is already over. 95 offenses. Is this matter wrong? Eleven. 10, 11. ಕೆಲವರಲ್ಲಿ ಮಧ್ಯಾಹ್ನ ಸೈನ್ ಆಗೇ ಬಿಟ್ಟಿದೆ, ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. ಸೀರಿಯಲ್ ನಂಬರ್ 10 10 11